Good afternoon, ladies and gentlemen. Welcome to the George W. Norris Legislative Chamber. The afternoon session is about to reconvene. Senators, please record your presence. Roll call. Mr. Clerk, please record.
There's a quorum present, Mr. President.
Thank you. Any items for the record?
I do, Mr. President. Your Committee on Revenue, chaired by Senator Linehan, reports Legislative Bill 1047 and 1134 to General File, 1134 having committee amendments. Additionally, amendment to be printed from Senator Conrad to LB 287 and an approved reference report from the executive or from the reference committee concerning several gubernatorial appointments. That's all I have at this time, Mr. President.
Thank you, Mr. Clerk. Please proceed to the first item on the afternoon agenda.
Mr. President, Legislative Bill 175, when the legislature left the bill this morning, pending was the bill itself, a committee amendment, and an amendment to the committee amendment from Senator Wayne.
Returning to the queue, Senator Conrad, you're recognized to speak.
Thank you, Mr. President. I yield my time to Senator Dungan if he so desires.
Senator Dungan, you have 4 minutes, 50 seconds.
Thank you, Mr. President. Good afternoon, colleagues. Welcome back. As we last were here on As the Legislature Turns, we were having conversations regarding LB 175 and the many amendments on the board. So I want to be very clear. I am going to take some time and we're going to talk a little bit more here. And I see there's some other people in the queue because we did reach an agreement over the lunch hour, at least with some of the interested parties. I need to talk with Senator Slama about it. I'm waiting for some language, but there is a version of the bill that we are now getting an amendment wrapped up to that I've been told the landlords support. I've been told that I believe the realtors support it. I'm still waiting on one other person to have a conversation with, but we are waiting on that amendment. And once I get eyes on that, I'll have a conversation with individuals about that. But we need a little bit more time. So just letting everyone know that is why we are going to be stretching a little bit. While we are here, I think it's important to talk a little bit about why this jury trial right is something that I believe is going to be inevitable. I don't want to just sit here and read the opinion because I know that can be a little bit boring. No offense to Justice Papik, who wrote it. I'm not saying his writing is boring, but I'm not just going to sit here and read a legal opinion. But I do think it is important to talk about why he says, quote, "I believe the bench trial provision may rest on constitutionally fragile ground." Colleagues, one of the most important parts of our Nebraska Constitution is Article 1, Section 6, which says unequivocally, the right of a trial by jury shall remain inviolate. So you have a right to a trial by jury. He says, "We've long understood this provision to preserve the right to a jury trial as it existed at common law and under statutes in force when the Nebraska Constitution was adopted in 1875. So what that means is if you had a right to a jury trial when the Nebraska Constitution was adopted in 1875, it would make sense that you have a right to a jury trial now. And in fact, you are constitutionally afforded that right. There's multiple cases that have said that time and time again. As a result, when a party contends that it's constitutionally entitled to a jury trial, what the court does to resolve whether that's right or not is they look at whether or not the action is equitable or legal in nature. Now, I'm not going to bore all of you with my sort of piecemeal explanation of the difference between an equitable action or a legal action, but a legal action essentially is one that results in an actual gain of damages, right? So like money or property or a thing. That is a legal action where the actual benefit you get is substantive in nature. An equitable action is slightly different. An equitable action is something that can be determined by looking at the facts and determining, for example, like whose name would be on a contract or things like that. So it's not that same kind of damages or receiving actual physical property. And what they specifically say in here is that the relief awarded if the landlord prevails is restitution of the premises. So in an eviction action, the actual relief that you are given is the restitution of the premises. You are getting physical control back over that property. Therefore, the court has found time and time again that an action for restitution of premises is a legal action and not an equitable action. He says in this opinion, just 2 years ago, we observed that an action for restitution of premises brought under the Nebraska Uniform Residential Landlord Tenant Act is an action at law. That's settled. That is settled law. That there's not any dispute, at least in Nebraska, about whether or not this restitution for premises is a legal or equitable action. So this isn't just Nebraska. There are many other courts that have concluded the similar actions by a landlord to evict a tenant and recover possession of real property are legal in nature, and thus are subject to a similar constitutional jury trial guarantee. The most notable of those, the court outlines, is the United States Supreme Court, in a case called Purnell v. Southall Realty, already made the determination that you have a constitutional right to a jury trial by virtue of the fact that an eviction action is legal in nature. So, if the U.S. Supreme Court has decided that, why does it not pertain to us? That's a fun question. The answer is, in that case, the U.S. Supreme Court was talking about a District of Columbia summary eviction statute, which was analyzing the Seventh Amendment. The Seventh Amendment, because it's actually federal land, was applying in D.C. Thank you, Mr. President, but it did not apply to states. So the U.S. Supreme Court has already reached the decision way back in the 70s that these kind of actions are legal in nature and therefore have a jury trial guarantee. Bouncing off of that, there have been many other states that have made similar or almost identical analyses. I listed a few of those earlier, but I think it's important to note that, again, Supreme Courts in Alabama, Georgia, Maine, West Virginia, and Florida have all reached that same opinion based off of that same analysis that the Supreme Court used. I will go ahead and stop there, as I'm sure that I'll talk more about this in a little bit, but I need to go check in with some people. Thank you, Mr. President.
Thank you, Senator Dungan. Senator Michaela Cavanaugh, you're recognized to speak.
Thank you, Mr. President. Good afternoon, colleagues. I hope you all had a good lunch break. So as Senator Dungan stated, he's working on an amendment to come forward soon. So I thought I would just take this opportunity to share a little bit more with you all from the Intergenerational Poverty Task Force report that I started talking about yesterday. So this is page 7 of the report, Minority Families in Poverty. In 2015, Nebraska had higher rates of minority families in poverty than the nation as a whole. A little over a quarter, 25.3% of Nebraska's African American families with children under 18 were in poverty, compared to 21.6% of Black families in the United States. The same pattern is reflected in the data for the state's Hispanic families. Almost a quarter, 24.4% of Nebraska's Hispanic families were in poverty, compared to 20.1% for the country as a whole. Asian families in the state fared even worse compared to national levels. 22.1% of Asian families in the state living in poverty, compared to 8.7% nationally. Across the board, households headed by single women had higher rates of poverty than the national rates. The poverty rate for African American families headed by women in Nebraska was 7.4% higher than the country as a whole. Hispanic families led by women had a poverty rate 8.6 higher. Families headed by Asian women had rates over 3 times higher than the national rate. There's a figure now in employment, as reflected in figure 3 in 2015. The majority of Nebraska families in poverty were headed by someone who was employed. About 2/3 of both married couples and single families were headed by someone who worked full or part-time. Almost 71% of households headed by single females worked full or part-time. I thought that this information was apropos to the conversation today about housing, because what we're really talking about is affordable housing, secure housing, keeping families in their housing, finding the best way forward to ensure a fair and equitable housing policies. I think that there's a misunderstanding that there's an intention to harm landlords, but the reality is that we need to be doing more to ensure that families can stay in safe, secure, affordable housing. I know landlords, and I know of a landlord in Omaha who took on a client or a tenant who had been evicted, and it was sort of an emergency situation, and they they took her in, and she was a single mother, and there were problems with the home that she was renting from them. And she didn't tell him about the problems because she was terrified that she was going to be evicted if she made too much trouble. And he told her, you really need to tell me when there's problems. This is property I want to invest in. I want to keep it nice. So if the water heater goes out or there's a broken window or whatever it is, please let me know and I will take care of it. I promise I won't evict you. But she has been trained to think, if I make a problem for my landlord, I'm going to get evicted. And this is something that we need to face as a reality for a lot of single mothers specifically, that they are concerned about getting evicted because they make too much trouble. And I would call it good trouble.
1 minute.
It's good trouble when you're a parent and you're trying to ensure that your child has a safe place to live, a warm place to live, that they don't have bed bugs and cockroaches and freezing rain coming in through a broken window, and they have a hot shower. So I think that we kind of got off track today on focusing on the bad apples of tenants, when the reality is we're trying to help single families, working families to stay in their home and be safe. Thank you, Mr. President.
Thank you, Senator Kavanaugh. Senators Ibaugh and Conrad would like to recognize some guests in the north balcony. Students, alumni, and supporters of the University of Nebraska here for I Love NU Day. Please stand and be recognized by your Nebraska Legislature. Senator Linehan, you're recognized to speak, and this is your third time on the amendment.
For a year.
Just a new federal requirement.
Right. Got it. Okay. Great.
Thank you, Mr. President.
Okay.
And I need to.
Introduce that.
I'm going to try not to sound like I'm lecturing. I'm going to try and sound not like grandma, but I'm afraid it's going to sound a little like that. So we're about that time in session where we got a lot of work to do. And the only way we're going to get it done is if we all get along. And another thing that the only way we're going to get it done is you're going to have to trust your committees just a little bit. I am perplexed by this whole conversation. We do. I wish Senator Hunt was on the floor because I'm going to quote her. We did last year. How did she say it? Rolled and stacked the committees. We did. We weren't secret about it. And I'm saying we, it's the majority. But there's one committee, Judiciary. Chairman Wayne got to be chair, but we made sure we had 4 conservative votes on that. Right? Yep. 4 conservatives. A prosecutor even, Senator Bozen. I feel bad for them because they're all in their early careers here. But they decided this was a good idea. And I'm very, very proud of them because they have stuck to it. Because they actually know a lot more about this than any of the rest of us. But somehow we're not listening to them. It is not, we're not saying landlords can't evict people. We're not saying that, people ought to get free rent. We're trying to help a little bit on the edges, guys, a little on the edges. Here's some statistics for you. Through 2016 to 2019, there were 6,286 evictions. In 2022, there were 8,650. In 23, there were almost 11,000. 27% increase in 1 year. This is a problem, folks. And all you have to do is read a newspaper. We have homeless tents in Omaha. We have places popping up. I drove by Westroads the other day. It was very clear to me in that corner at 96 and Dodge where you can never see anything in there because it's all trees and it's all leafed up, but there were piles of trash. People are living there. So that's not a problem we can solve. I'm not even saying nobody's got a bill to solve that. But we're refusing to like tinker with the edges. It doesn't make any sense to me. So the main reason I'm talking though is I do want to tell Senator DeKay, Senator Holcroft, Senator Ibach, Senator Boston, I have passed bills on this floor. I have lost several times on a filibuster. But you don't give up about doing the right thing and the things you know. And you're all coming back, and whatever happens with this, you'll have another swing at it. So hold your head up high and be proud of yourselves, because you know what you're doing. Thank you.
Thank you, Senator Linehan. Senator John Kavanaugh, you're recognized to speak.
Thank you, Mr. President. Yes, tough act to follow. And if it was appropriate to clap on the floor, I'd be clapping right now. Senator Linehan and I have, as she stated, she's lost some fights on the floor. I've been on the side that won when she lost, and she's won some fights on the floor, and I've been on the side that she won and I lost. But it should really tell you something when Senator Linehan and I are on the same side of an issue. This is a good bill. This is a good compromise. As she pointed out, the committees this year are structured in a certain way, and particularly judiciary is structured in a way that if something comes out of judiciary unanimous, it's probably been negotiated to within an inch of its life to solve a problem in the most narrow way possible, and that's what this bill does. And so you all know, and I actually, this is the first time I think I pushed my light on this bill, which is kind of funny. I was out counting. I talked to everybody, counting everybody's votes. If I didn't talk to you, it was because I couldn't find you. But I did answer a few questions about having volunteered in landlord-tenant court. I volunteered through the Volunteer Lawyers Project in Douglas County. Had the opportunity to see how these courts work and how they don't work, and I've seen what is happening with folks who didn't have representation before, and now people come to court when they know there's going to be representation. People are showing up more. You know, this is kind of evolved over the years, where landlord-tenant court was many people just didn't show up because they didn't expect anything different to happen. And then we had some monies available for emergency rental assistance, and which was a great win-win because people got to stay in their apartments and landlords got to be made whole through getting paid back rents, and we helped people. And that was something we started doing during the pandemic because we discovered, or we knew, but had not really considered, that stable, safe housing is a part of quality healthcare system, really. And we know that people becoming unhoused in a one-day turnaround leads to homelessness, leads to loss of employment, leads to problems in our schools, leads to crime, leads to a whole lot of other problems and social ills that we hope to address by creating other structures to help people remain housed, but without putting or taking away the rights of property owners. And so that's what we've done on previous bills in the space, and that's the balance that's being struck here, is that we're helping this bill, where are we? LB 175, AM 2504, AM 2754. So AM 2754, I think, would be best described as the committee amendment, which is really the package of the bill, and it includes jury trial, which I know a right to jury trial, which Senator Dungan just sort of went through the federal constitutional implications of that. He's previously discussed the state Supreme Court implications going forward and why this bill has kind of come to us at this point.
1 minute.
Thank you, Mr. President. And I was not not on judiciary, was not part of the negotiation of this, but was privy to some of the conversations about the jury trial negotiations. And I would tell you that Senator Dungan and Senator DeBoer, who worked on this bill, have negotiated on this and made it less expansive than I probably would have personally done, but did find ways to make it work better. And there is a legitimate concern that if we don't solve the problem, a solution will be forced upon us. And I'll push my light again because I haven't talked very much and I have more to say on that topic. But it's not a Chicken Little situation to say that there is a real possibility that we're going to have to solve this problem. And so this is a opportunity to get out in front of it and solve the problem in a constructive, collaborative way before we have to scramble to solve the problem. And so I appreciate the work that Senator Dungan has done on this. I appreciate the work of the Judiciary
That's your
Committee on
time.
this. Thank you, Mr. President.
Thank you, Senator Kavanaugh. Senator Ibaugh has guests in the South Balcony, fourth graders from Pershing Elementary in Lexington. Please stand up and be recognized by your Nebraska Legislature. Senator Blood, you're recognized to speak.
Thank you, Mr. President. Fellow Senators, friends all, I do support both the amendments and the underlying bill. As you heard earlier, the Judiciary Committee has more work to do on many, many things, and now I'm being called to go into exec. But I would like to yield the rest of my time to Senator Dungan.
Excuse me, Senator Dungan, will you yield to a question?
No, I'm yielding my time.
Senator Dungan, you have 4 minutes, 25 seconds.
Thank you, Mr. President, and thank you, Senator Blood. I appreciate your hard work, and as was already talked about, I know the Judiciary Committee has a lot going on right now, so thank you for your hard work on that committee. I want to take a second to genuinely thank everybody on the committee for working through these. These are not easy subjects, and even attorneys that I talk to who don't specialize in landlord-tenant law struggle to fully understand all of the things that we're talking about here. And the problem is you're dealing with just so many different layers. It gets really complicated. And members of the Judiciary Committee, not everybody has a legal background, and I know it can be difficult to sort of grasp these, but I want to say thank you to all of the members of the committee for working through this. Senator Linehan is spot on that I think trusting our committees is vital. I know the work that I do on the committees is trying my hardest to help craft packages and things that are the bills that come out in a way that makes sense, and we rely on committee statements. You know, we really do, genuinely. People watching at home, we do our best to review every piece of legislation that we have before us, but the sheer multitude of things that are on our desk make it difficult to see every single aspect of every single thing. So a committee statement is huge. And when we get a committee statement and we look at it, and it says something came out 8-0 or 7-0 or 9-0, whatever, how many people are in your committee, what that means, what that indicates to the rest of the body, or what it should indicate, I think genuinely, is that there's agreement. And especially with the Judiciary Committee that is split down the proverbial aisle 4-4 when you're talking about people on different sides of different issues, when you see something in consensus, I think it is usually indicative of the fact that a lot of hard work has been done to get there. I won't walk you through all of the efforts that we went through with LB 175 and the attached bill that we're, well, the AM 2754 is LB 1115, but it was many, many, many months of work and many, many, many meetings that happened between myself, my incredibly hardworking staff, and a lot of the advocates on both sides of this issue and the experts on both sides of this issue in an effort to find a way to craft legislation that was both achieving a certain goal, but was also workable. One of the things that I always think of as an attorney when I'm here is when I read a piece of legislation, I think, how does this actually work or operate? And when you start to actually look through these, sometimes we legislators have a really good idea, or we think we have a good idea, and we try to pass a law that changes the way the courts work or the way something happens, but then you actually are in the courtroom trying to make it work, and judges and attorneys as practitioners start to think to themselves, how do we do this? How does this operate? And that's been the real challenge with LB 1115, which was the bill that has the right to jury trial restored for the eviction actions. And I say restored again to remind my colleagues that we had that right up until 1995. But it was really the practitioners that I wanted to speak to. And so as recently as yesterday, I spent about an hour on a Zoom call with a county court judge representing judges all across the state and other experts talking about questions they had of how this would work.
1 minute.
Thank you, Mr. President, and what we could do to make this operate. And they raised a number of, I think, very legitimate questions. And that's why you have to crowdsource these things. That's why you have to talk to people in order to fully understand what the pitfalls might be, what the benefits might be. And so I actually think Senator Slama was spot on when she said it's good that we're slowing down and having these conversations, because when you start passing large pieces of legislation that modify the way our courts work, it can be very tricky. So that is a long roundabout way of saying I appreciate the input from the experts. I appreciate the help that I've received time and time again from judges and attorneys. And I really do think what we came up with in LB 1115 was the result of a lot of thorough analysis. And as I said in my opening, is likely to have tweaks on select. So please, if you have questions, if you have concerns, come talk to me. We are open to modifying things very clearly, and we are happy to work with other colleagues. Thank you, Mr. President.
That's your time. Oh, excuse me. Thank you, Senator. And Mr. Clerk.
Mr. President, the Judiciary Committee is currently meeting in room 2102 for an executive session. Judiciary Committee is in room 2102 currently for an executive session.
Senator Erdman announces 3 guests under the south balcony: Dylan Metz from Bridgeport, Caitlin Miller from Maxwell, and Jeff Metz from Angora. Please stand and be recognized by your Nebraska Legislature. Senator Walls, you're recognized to speak.
Thank you, Mr. President. I yield my time to Senator Duncan. Thank you.
Senator Duncan, that's 4 minutes, 54 seconds.
Thank you, Mr. President, and thank you, Senator Walls. I think this is the most I've ever actually talked in a row on the microphone. Certainly not the most I've ever talked in my life. There's many times I've talked a lot more and pontificated longer than this, but this is the most times I've ever talked back to back to back. And I will say I have a newfound respect for senators like Senator Slama and Senators Michaela Cavanaugh when I know they've had to do this for long periods of time as well. So I do appreciate the experience of getting to do this. Just to finish up my thought briefly before we continue to delve into a couple of the other issues with regards to clean slate and jury trial, there's, like I said, there's multiple modifications and amendments that are going to have to be made between now and select. That is the way these things work. And I have been very open about the fact that we are willing to modify things. I've been very open about the fact that I'm willing to work with everybody. And I'm actually very pleased to say again, there's been another amendment that we're currently waiting on, so I apologize for the delay, wherein over the lunch hour, I was able to meet with representatives for landlords, and I really do think we found something that everybody can agree on. So we're just waiting to get that up on the board. In the meantime, I want to go back to the Supreme Court decision that Justice Papik and a couple of other justices ultimately wrote as a concurrence in that Holcomb case. There's a couple parts that I do want to read verbatim because I think that they're important to highlight here, and I'm trying to make sure I find the right section. So one thing that I think is interesting is how justices or legal scholars can reach similar conclusions from different areas. So obviously, we're all aware that some people are originalists, right? Wherein they believe that a certain thing should be the way that it was when the Constitution was first written, and that we should see the Constitution not necessarily as a living document, but as something of a more structured document and look to it from a more historical perspective. I know the U.S. Supreme Court has recently moved into a more originalist perspective, and I think it's really interesting when you start to analyze the history behind some of the ways that we've reached our current structures. Of particular note on this opinion, it says a landlord-tenant eviction proceeding in 1875 would have been triable to a jury under both the Nebraska Code of Civil Procedure and the forcible entry and detainer statutes then in effect in Nebraska. The fact that these statutes codified the same right to a jury trial that existed for real property possession actions at common law is unsurprising. In 1866, the territorial legislature of Nebraska adopted and declared the common law of England to be the law in Nebraska to the extent not inconsistent with the U.S. Constitution. The organic law of this territory, or with statutes passed by the legislature, now codified at Nebraska Revised Statute 49-101. The jury trial provision in the Nebraska Code of Civil Procedure and forcible entry and detainer statutes that existed in 1875 thus could be understood as the legislature's attempt to faithfully implement the common law right to a jury trial and possession actions as the law in Nebraska. Despite all of the foregoing, NP Dodge and the Attorney General, who filed a brief defending the constitutionality of the NURLTA, the Landlord-Tenant Statute bench trial provision, argued in this case that Article 1, Section 6 of the Nebraska Constitution does not require that actions for possession under the Residential Landlord-Tenant Act be triable to a jury. Their primary argument in support of this position was that such actions are special or summary proceedings. They contended under a certain case that the constitutional right to a jury trial does not extend to special or summary proceedings. So,
1 minute.
Thank you, Mr. President. I don't want to go too deep down into what a special or summary proceeding is, but the Supreme Court responds, the argument however, has some flaws. As an initial matter, the statement that NP Dodge relies on from that case is dicta. Dicta is a fancy way of saying it wasn't the main holding of the case. The issue in that case was whether the jury trial guarantee applied to a quo warranto proceeding. Furthermore, other dicta in that case is contrary to the argument of NP Dodge and the Attorney General's argument in their brief. That case quoted other language from the same Arkansas Supreme Court opinion that stated, so far as our research has extended, the right of trial by jury at common law only extended to criminal prosecutions and in actions where a freehold or goods and chattel were in dispute. The term goods and chattel includes personal property, choices in action, and chattels real. So once again, this goes back to what you're actually trying to gain.
Senator.
Thank you, Mr. President.
Senator Conrad, you're recognized to speak. Next in the queue, Senator Lowe. You're recognized to speak.
Thank you, Lieutenant Governor. You know, as a landlord, I look at this and I try to pick good tenants. And by doing so, I look at their reference letter. If that reference letter doesn't show anything, it shows a red flag to me. And I think will be the case of this. Is it may have the opposite effect of what we want to do. So if a tenant comes to me or a prospective person comes to me and they have no prior rental on their application, what am I supposed to assume? With that, I yield the rest of my time to Senator Slama.
Senator Slama, will you yield to a question? Or yielded time, and it is 3 minutes, 57 seconds.
Thank you, Mr. President. No worries, you'll get there someday. And thank you, Senator Lowe. I do appreciate, again, the people sharing on the ground level what their experiences have been like as landlords, as tenants. I've been a tenant. I haven't been a landlord. If I end up following Dave Ramsey's financial advice, I will end up being a landlord someday, passive income, whatever. But I appreciate the discussion. I am in kind of a little bit of confusion just based on where we're at with debate, because I keep hearing that there's an agreement, but everybody who's a point person on the floor for the opposition to this bill has no idea what's going on with it. And I would love to hear what the agreement is. I'm hopeful that it's what
I was discussing, which is the LB 1115 language that Senator Dover had offered, and eliminating the core language of LB 175. If it's not, I mean, we can be here for another 2 hours and 45 minutes pretty easily. I already showed off my wonderful filibinder that my staff has put together, but I really would love to be looped in. So I will ask if Senator Duncan will yield to a question.
Senator Duncan, would you yield to a question?
Yes.
So I'm going to ask this question and I'll let you have the remainder of my time because we can't double yield, but would you be willing to share with the world what this agreement language is?
Yes. Is that a question or a yielding of the time, just to make sure?
I'm asking you a question, but I cannot yield you time because I'm double. So.
No, I understand that. And I'm not trying to be evasive. I remember there's that episode of The West Wing where I think Josh gets up on an accident and says they have a secret plan to fight inflation. And everybody's wondering what the secret plan is and he can't really get to it. No, it's the reason that I'm waiting to actually go into details about it is we're waiting to actually get the language back. Ultimately, in talking with the representatives from the landlords and in talking with the representatives for the realtors and in talking with other interested parties from the court and also the advocates world, what I believe the amendment that we're trying to get together, what it would do is, unfortunately, Senator Slama, I don't know if you're going to like it, but we'll keep talking about it, remove the portion with regard to the jury trial. So 1115 would not be a part of the bill. It would remain with the clean slate portion, the 175. It would still be limited only to people who have not actually been evicted. So it still keeps out that 3-year look back. It also would only be allowed to be used one time. And that is to prevent against repeat offenders, which I've heard a lot of concerns about. Thank you, Mr. President, wherein somebody would continuously have these evictions brought against them and for whatever reason not ultimately perfected or executed. So you'd only get the benefit of the clean slate one time, and that's to really protect the people who need it. In addition to that, I believe it also incorporates a bill from Senator Dover that had been discussed in committee that I believe came out 8-0 that has to do with e-notice for landlords. And so once I get that actual language, I'll be able to get it up and we can talk more about it, and I'll go into more detail about it, but that is what we're currently waiting for. That is my understanding of the outline.
Well, thank you, Senator Duncan. I appreciate that clarification. I'll be clear that I'm not on board with that proposal. Obviously, we'll discuss it more. If we need to take it overnight, we will. But if we're eliminating the 1115, I mean, clearly the constitutionality portion of this isn't as urgent as we've been discussing. If we're just eliminating it, which is the concern I was hoping to address in negotiations.
Senator.
Thank you, Mr. President.
Thank you, Senators Slama and Duncan. Senator Michaela Cavanaugh, you're recognized to speak, and this is your third time on the amendment.
I am very tempted to yield my time, but I see they're speaking off the mic now, so I'll let them sort it out and I'll just take my time. I did have to Google Dave Ramsey because clearly I'm not great with my money. And at first I thought that Senator Slama was saying Bill Ramsey, who's the weatherman in Omaha. And you can always tell how bad a storm is based on his shirt sleeves. So at the start of like reporting on a storm, Bill Ramsey will have his shirt, what? Ramby. Oh, well, yes, Ramby. Sorry. Thank you, Senator Mosier. Bill Ramby, he will have his shirt just buttoned at the sleeves. And I think we're going to have a winter weather storm. And then as the blizzard snow-nado comes, or what did we have a couple weeks ago? An Arctic blast? I don't know. So then he starts rolling up his sleeves. And if his sleeves get all the way up above his elbows, we are in for it. Whatever season it is, there's going to be a tornado tearing down houses. There is going to be a snow tornado. There's going to be a monsoon. If Bill Ramby has his shirt sleeves above his elbows, all bets are off. I hope you went to the grocery store. GoPuff is going to be shut down. You can't get your drinks or food delivered to your house. I really hope you have enough toilet paper. That's kind of a critical one. Dave Ramsey. This is a group effort. Thank you, Senator Walls and Senator Mosier. Dave Ramsey has a program.
that former Senator Sarah Howard followed and was on, oh, she was on his show. That's right. I have no idea how she got debt-free in this job. But she did it. She must have eaten a lot of ramen. I think that actually once Senator Lowe talked about his son eating ramen and ketchup packets for a month, right? It was for a month to stay on budget. That sounds very unhealthy. I hope he doesn't still do that. See, I'm always listening. I'm always listening to the floor debate. And if you listen, sometimes, it might droll on, especially when the other Senator Kavanaugh gets on the mic and he just uses his soft voice and I'm an attorney and I want you to fall asleep and I'm going to say some Latin words and then you're going to just fall asleep and not listen to what I'm saying. But sometimes if you listen, he'll rickroll you. So yeah, obviously I'm just kind of chatting with myself. This feels familiar. This is like last year when I would just kind of chat with myself. I will say I appreciate the shout out from Senator Dungan on the filibustering Senator Slama and I have done. I will say, however, Senator Dungan, until you have done it in heels, you don't even know what a real filibuster is all about. You got to do it in heels too. So, how much time do I have left?
A minute, 30 seconds.
Wow, great. That's great. It's really awesome. It's Wednesday, March 6th. Who knew I could run out of things to say? Oh, I hate to do that to you. Senator Slama, would you like the rest of my time?
1 minute. And Senator Slama, you have 1 minute.
Thank you very much, Mr. President. And thank you, Senator Kavanaugh. No, I'm grateful we're here. Negotiations are ongoing. It doesn't sound like I'm amenable to the proposed amendment, but we haven't seen language yet. So I've told Senator Dungan in good faith, I will reserve judgment until I see it in black and white. But I am grateful that my filibuster against big government has stunned Senator Michaela Kavanaugh into silence. So God bless us, everyone. I'll leave it on that note. Thank you, Mr. President.
Thank you, Senator Slama. Senator John Kavanaugh, you're recognized to speak.
Thank you, Mr. President. I missed a bit earlier. Was Senator Michaela Kavanaugh making fun of my speaking style? It was making fun of my speaking style. I would gladly make fun of her speaking style, but I do not possess the theatrical skills to do so. So I do have other things to say about the bill, but just to go off of what she was talking about, I think she was hinting at the old adage that Fred Astaire was a great dancer, but Ginger Rogers had to do everything Fred Astaire did backwards and in heels. And so she was better, which, of course, there's the Fred Astaire house in Omaha that there was a great article in the Omaha World Herald fairly recently about the restoration of that house. It was very interesting. I'd encourage everybody to go read it. It's a house that had not been updated. It's more than 100 years old. Still, I don't think it had electricity, so it hadn't really, still kind of pristine to its older age. So apparently I do have can have a monotonous speaking style, I'm told. With the grayness in here and everything, it does feel like I could put some people to sleep. I could certainly try. But I digress. I'll go back to the bill, talking about where we are circling around. I think some folks are off the microphone, learning about what's potentially in an amendment that we're waiting from drafting that maybe helps solve some of the concerns that have been articulated. And like Senator Slama, I would encourage everyone to reserve judgment until we see what the actual amendment does. As we've all learned many times here, that there are ideas and then we put them into language and they can look very different. Someone's idea looks different in legislative language than someone else's idea. And so it's important to wait and see exactly how it actually comes together. But I'm given to understand, and based off of my conversation with so many of you, all of you really, when I was counting votes earlier, that this amendment will solve a number of people's issues once we get it. And to go back to why this is important, I was talking last time on the microphone about the detrimental effects of people becoming unhoused in a quick fashion. And when Senator Linehan asked me a question earlier, I told her the anecdote about one of the times I was volunteering at the landlord-tenant court, and this individual came in and said they were just there to make sure that they didn't go to work and come home to find their door locked with their dog inside. And we were able to connect them with services, and we were able to negotiate with the landlord, where the landlord got the back due rent plus some forward-looking money, and they did still want the person ultimately to vacate, so they agreed to let them stay for another month while they got their stuff out and found another place, and let them pay for that month. Which was beyond this person's wildest dreams. They were so happy about not finding themselves homeless at the end of that workday. And the landlord received somewhere in the thousands of dollars as a result of that negotiated settlement. Whereas when Senator Von Gillern asked me earlier what happens, so the result of that was that the landlord got 3 months rent and some costs and things paid, and that was guaranteed money. And then, but if that had gone to trial that day and there had been the determination by the judge that a restoration of premises should be issued and the person should be evicted.
1 minute.
Thank you, Mr. President. The landlord, yes, would have been able to go and change the locks, and that person would have come home and their dog would have been locked inside, and they wouldn't have been able to get their stuff, and all of those terrible things would happen. But the landlord would have been out all that money and then had to file a collection action against that person and then seek that money separately. And again, trying to get money from somebody whose reason that they became unhoused was because they didn't have money, it's going to be hard to collect that money, and it's going to take time. It's going to take more money to collect it, and you're going to have just more expense and less money ultimately. So there's a lot of great reasons why the Volunteer Lawyers Project is really important. There's a lot of terrible ancillary effects as a result of people becoming unhoused in these crises. What this bill as a package does is just ensures when somebody has a legitimate claim or defense, they have an opportunity to litigate that under a jury right.
That's your time,
Thank you, Mr. President. I'll push my light again.
Thank you, Senator Kavanaugh. Senator Jacobson, you're recognized to speak, and this is your third time on the amendment.
Thank you, Mr. President. Well, I don't want to sound like a broken record here, but I just want to kind of come back to the basics. I'm just a pretty simple guy. I kind of think about this from the standpoint as a lender. I loan money to people to buy, build, or purchase, rental properties in many cases. Sometimes it's single-family residences, sometimes it's fourplexes, duplexes, or larger apartment complexes. And the deal I make with them as a lender is, we'll loan you the money to purchase this, and then you agree that every month you make a payment to us to pay the loan off with interest. And you keep the taxes current and you keep the insurance current. And here's their deal. Their deal is that they're going to rent to people who will pay them rent on time every month within a certain grace period, so that they can collect those rents and be able to pay the taxes, the insurance, and the principal and interest payments to me. It's an interesting concept. And if everything works well, you'll be able to one day pay the property off and build wealth. It's a unique part of capitalism. But where you run into problems is when the government gets involved and makes deals that changes the game in the middle of what you've been doing, and suddenly says, like we did during the pandemic, you can't evict anyone. Well, it's a novel idea. It's the kind thing to do, but it does disrupt their ability to get those monthly payments that make payments to me, and it jeopardizes them losing the investment that they invested in, with an understanding that the people that came into their property would pay them when the rent was due. Now, we've heard a lot about people that are just a few days late but have been model tenants otherwise. Well, you know what? You're not going to get evicted. You might start an action. Yeah, I get some of these major mega owners might start an action, but you know what? You get paid, it all stops, and you stay where you're at. So you don't lose the house. You're not looking for another place to live. And I can tell you, if you're homeless, it's because you can't afford to make the rents, because you're not taking a job, many of which are available out there that would allow you to live in a place and be able to pay rent. Maybe not as nice a place you had before, but you wouldn't be living in the street. There's plenty of jobs available. This is possible to get jobs. In fact, here's a novel idea. Some have 2 jobs, and they're able to stay in housing. My concern is we keep chipping away. My other concern is this. How many times, just think about this, there's young lawyers coming out all the time from the university and other places, and they're looking for income. So I can picture now where you just simply put up at every apartment complex or run ads in the newspaper, if you're being evicted, give me a call. So what do they do then? So they're going to say, well, if you're in the middle of eviction, here's what we can do. Instead of paying your rent each month, you pay this month, pay it to me. I'll file an action against the landlord to prevent the eviction. We'll threaten a jury trial. We'll do all this other stuff, and we'll make the landlord settle with us. And then we'll get this wiped away from your record. So when I said earlier, is this going to be possible? Yeah, I think it's probable. Not possible, probable. We always like to talk about that unique situation where somebody just missed, just late, and they got thrown out and they had trouble being able to find another place because this is on their record. I'm afraid that would be the minority situation. I think this would really be gamed under the current process. Now, I've heard some pieces about the amendment. If the amendment comes back, I've heard that the amendment would eliminate the jury trial, which is unique because I thought that was one of the biggest problems we were trying to fix, was to have this jury trial thing. I still remain concerned that if the landlord is not able to stay current on his payments, and if the rent payments are not coming every month of somebody getting evicted, that's a problem. That has to be in place. And I won't support anything that doesn't have that in place. So I'm anxious to see the amendment, and hopefully we can keep moving forward. But again, there are problems with the bill the way it's drafted today. I appreciate the work of the Judiciary Committee, but I'm not sure any of those were landlords. So if you are a landlord, you understand it a little bit different perspective. Thank you, Mr. President.
Thank you, Senator Jacobson. Senator Frederickson, you're recognized to speak. Next in the queue, Senator Walls. Senator Hansen, you're recognized to speak.
Thank you, Mr. President. Is Senator Duncan on the floor? I was hoping to ask him a couple of questions. If not, I can ask Senator Kavanaugh. Okay. I got lawyerly questions I was hoping to ask, and pardon my non-lawyerly verbiage. I just thought of some of these questions when I was downstairs listening while I was doing some work, and I don't think I heard them on the mic yet. And so I think these are maybe some that I've asked you before, and then some maybe you can kind of clarify for me. So I think you mentioned before that if someone gets evicted and they want to go to a jury trial, we're expecting just somewhere to take about 3 to 4 weeks, typically around there, by the time a jury trial is put together. Would you, on average? Oh, well, Senator Duncan, yield to a question.
Senator Duncan, will you yield to a question?
Yes.
Can I ask you the same question?
Sorry, and I apologize, I was trying to follow. Is it about how long it would take before somebody goes to a jury trial?
Yeah, I'm trying to put timelines together here. So yes, and I got a few questions, so
Sure.
just FYI.
So here's part of the complicated factor, and I'm going to give you the most lawyerly answer of all time, which is frustrating. It depends.
That's a good political answer too.
It is, I know. Every county court and district court does their jury trial terms, we call them jury terms, slightly differently. And that's part of the reason that we did not, in this legislation, originally dictate the terms and the timing of when they have to have the jury trial. I can tell you that in Lancaster County Court, which is where I practice, usually speaking, there is a jury term every month or every other month. And so,
and then I know it's like certain counties, like where I'm at, you get called in, they have to put it together. And so it usually can take longer than perhaps someone serving on a term who's already prepared to be there, correct?
That is correct.
Okay,
yes.
so is it possible then that sometimes these could, instead of taking 3 or 4 weeks, could take 3 or 4 months?
So if we're talking about a criminal case, yes. I've had cases that were set for jury trial that have had to get continued, but to the best of my knowledge, and I practiced for almost a decade, never had a case that was continued just because the court ran out of time during their jury term. The judge always found a way to get my case in during the jury term. The only continuances that happened were ones that we asked for. And that's why in this bill, it means that it says that if you're a tenant asking for a continuance, that you would have to pony up the rent if ordered by the court to ensure that that does get continued. So I don't believe there's ever going to be a circumstance where they just simply run out of time.
Well, not run out of time, but like 3 to 4 months, but say, okay, I mean, instead of 3 or 4 weeks, they say, well, we got your trial set up for 3 months from now.
I don't believe that would happen. No, I think the jury terms are going to be much, much sooner than that.
And this is just a question I had, and it may or may not be the case, but is it possible then that we could sometimes maybe see a sympathetic judge that to the plight of an individual such as this, that may intentionally or not intentionally perhaps prolong a trial, or for like instead of a month, maybe take out 3 months because they know that person's going to have to pay rent?
I think the number one thing on most judges' mind is judicial efficiency usually when they're running their courtroom. And so I cannot imagine a circumstance where they would drag it out just to try to be sympathetic to that extent. I know in all the courts that I've practiced in, the judges are primarily concerned with effectuating the law properly. And this law does say that they have to do it as quickly as possible pursuant to local court rules. And so I don't see or foresee a situation where a judge would intentionally continue it out. Generally, continuances are granted at the discretion of the judge for good cause.
Okay. You don't see it, but I could see maybe a possibility of that, but you're saying it's unlikely.
I think it's very unlikely, yes.
Okay. All right. So that's one of the concerns I had. So we would have maybe not a tenant paying rent, which that's beside the point. Is that, in my opinion, I think it's more important that we're seeing a landlord who's not receiving that rent possibly for a month or 2 or 3 months, while they're awaiting this whole process to take place.
1 minute.
And you brought up that point about in counties such as Lancaster and Douglas and maybe Sarpy, I don't know for sure, but they have those terms in a jury, where in such counties such as mine, we don't. It takes longer for that to happen. Also, one other quick question. And so in your opinion, have you seen an increase, either dramatic or not, perhaps in nonprofits or lawyers doing pro bono work in cases such as these in recent years?
I have not seen a dramatic increase when it comes to like nonprofits or pro bono work. I know that there is the Landlord Tenant Assistance Project that has cropped up, at least that I've been able to see at the Lancaster County Court, that I think is an arm of the Bar Association and often goes through University of Nebraska Law School. But it's not like a nonprofit that's sort of cropped up and propped up those individuals. It's primarily students or other individuals who are working for the Landlord Tenant Assistance Project, which is usually very small. And I will tell you, they're often, I see them there and they're running around working many cases.
Senator.
So thank you.
Thank you, Senators Hansen and Dungan. Senator Erdman, you're recognized to speak.
Thank you, Mr. President. Good afternoon. I wonder if Senator Dungan would yield to a question.
Senator Dungan, would you yield to a question?
Yes.
Senator Dungan, is it true we're waiting for an amendment to come down?
I just handed it to the clerk about 28 seconds ago before answering Senator Hansen's questions.
Okay, so there is actually an amendment in the works.
Yes, it has been submitted. It should be live soon. It's what I was outlining to Senator Slama earlier, and I will be happy to talk to it when we actually get to it.
So have you visited with Senator Slama about this?
I had spoken with her both prior to lunch and after lunch, after she asked me on the mic about what it contained. I don't know that it addresses all of her concerns, but it certainly addresses the concerns of many from outside the body and other people that I've talked to from both the landlord and the realty world.
Well, I think that that'd be a good idea, but I visited with her a few minutes ago and asked her if she knew what the amendment was, and she was puzzled by that. And so I think unless the amendment has been negotiated with her, it may be a little difficult to get your amendment passed. And what I was going to do is call the question. That's all I have for you, sir. I was going to call the question, but I found out the Judiciary and Education are having executive board meeting or committee meetings, and I didn't want to bring them back. But I'm not sure the amendment is going to accomplish much. And so we'll see what the amendment is. And the next time I come up, I'm going to call the question. Thank you. Yield my time to Senator Hansen.
Senator Hansen, you have 3 minutes, 30 seconds.
Would Senator Dungan yield to a couple more questions?
Senator Dungan, would you yield to some questions?
Yes.
Okay, I only have a couple more questions. I just ran out of time last time. And I appreciate you answering the ones that I had before. And so I was going back to the idea that there might be nonprofit organizations or lawyers possibly doing pro bono work specific for cases such as these. And so, like, in your opinion, is there an incentive for somebody representing somebody who has an eviction? Is there an incentive for them to take it to a trial versus not?
No, not to the best of my recollection. The vast majority of these cases are actually settled very, very quickly and in their first appearance. So Douglas County and Lancaster County handle this separately, or handle it differently rather. So Lancaster County, from my understanding, because I've not practiced in this exact area of law directly, but my understanding is oftentimes what happens is they show up and there's a conversation between the tenant and the landlord's attorney, and they'd say, hey, if you do X, Y, and Z, we don't want to go forward with an eviction action. And they continue it for a period of time, and assuming the tenant fulfills those obligations, then the eviction action is dismissed. And that's the people we're talking about here. Douglas County, on the other hand, my understanding is oftentimes they will show up, they will enter the eviction order then, but then they will, I think, continue out the effectuation of that eviction or the writ, and they'll give a list of things that the tenant has to fulfill. And if they fulfill those things, like paying something or moving your stuff out, they will then vacate and reverse that eviction order, which is what this also seeks to address. And so there's not really an incentive to drag it out and take it any longer than that. Most people want to resolve these things. The only reason you'd really want to go to a trial is if you say, I have money, I want to pay you that money and I want to stay here, but maybe there's a dispute over some factual violation of the lease. And so, no, I don't see any monetary value to dragging it out, especially not from a tenant's perspective when they oftentimes don't have that money.
And I think that's the question I kind of had, and that's I'm somewhat ignorant to the topic, I think, here. And so that's why I'm asking some of these questions.
1 minute.
Is if somebody representing a case such as this, if they will end up getting paid more going to a trial versus not.
You know, I think attorneys' fees are always flexible. I don't represent landlords, but I certainly think that it's possible that taking something to a trial is going to result in more attorneys' fees, but we also accommodate in the bill for the collection of those attorney fees by the prevailing party. So,
okay, one more question before I run out of time,
Yeah.
sorry. And so if a trial like this does take 2-3 months, and then so the fees then, and the ruling is found against the person with the eviction, then they have to pay those 3 months possibly of rent, correct?
the court may order, yes, the court will order the tenant to pay the rent during the pendency of the case that's been continued if the tenant is the one asking for the continuances.
Okay. Is it likely that they'll pay the rent if they're 3 months behind and they couldn't afford it in the first place? Or would that just kind of be?
If they can't pay the rent, the case wouldn't be continued.
Okay. All right. Thank you.
Yep.
Thank you, Senators Hansen and Dungan. Senator John Kavanaugh, you're recognized to speak, and this is your final time on the amendment.
Thank you, Mr. President. I burned through those 3 times in the last 45 minutes. So I just couldn't resist interjecting myself in the conversation Senator Dungan and Senator Hansen were having. Just a few thoughts to Senator Hansen's question about judges being favorable towards tenants and prolonging the case. Obviously, as to echo Senator Dungan's comments, judges are all interested in upholding the law, judicial efficiency, doing the right thing, and not not really playing games. But there are judges who obviously have philosophies and perspectives. And if you have one such favorable judge or judge that you like, and anybody who practices in any court regularly knows the personalities of the judges, you more than likely would waive jury trial and set it for bench trial rather than prolong, keep coming back and risking that judge, being moved to another jury docket or another, court. If you draw the judge that you like, you're probably going to try and get it resolved in front of that judge at that point in time by waiving jury and having the bench trial, which in landlord-tenant court is held that day. So I think that's probably what's more likely to happen, though I have not seen judges who are going to be overly friendly to tenants. So that's one part of that conversation that Senator Dungan and Senator Hansen were having. I'm trying to remember what the other question was that I felt so strongly about. So I do think that we have the amendments on file, so we might be getting to it. I haven't had a chance to take a look at it myself yet, and I am curious to hear folks' thoughts on the further compromises that have been put forward. And I would go back to the conversation that Senator Linehan started this afternoon about the work of the committee and how they kicked out this bill 8-0 because of the compromises, and that we're obviously here in our, fourth or fifth hour of this debate, and Senator Dungan's working to find other more ways to compromise to make this bill work for more of the interested parties. And so the iterative process of the legislature that we've talked about so much this session, where we have the conflict nature of this place, where somebody brings a bill, we have a hearing, people ask questions, hopefully constructive, thoughtful questions that then get us to a place that helps get to understanding what the bill's trying to do, get to a place where we can figure out ways that we can serve the intent of the bill and the people of the state of Nebraska in a way that works for most people. And then the committee, obviously, after that hearing, could construct an amendment that contemplates what was raised at the hearing, kick out the bill, and then it gets on the floor. And there are those of us who are not serving on the committee who then have our opportunity to be heard on bills. And then, so you might run into other opposition that wasn't raised before in the committee or at the hearing, or other perspectives, which is why obviously we are all part of the conversation at this stage. And it's not surprising that you get to the floor and there's a necessity to find further changes and compromises that bring more interests or represent more people's perspectives and interests to get a bill to become a law, which is what the goal is here, of course. So I think that's where we're at, is another proposal after hearing the comments of the folks this morning. Thank you, Mr. President. After talking to people off the floor, after talking to the people who are in the lobby here in particular, who have had problems with this bill, I think that's what this amendment we're going to see here in a few minutes represents, the fruits of that labor, of this conflict. So the derived from that adversarial process and got us to another step along the way to get to a new proposal that is addressing those concerns. So I look forward to hearing the introduction of the new amendment. Thank you, Mr. President.
Thank you, Senator Kavanaugh. Senator Lowe, you're recognized to speak.
Thank you, Lieutenant Governor. As I stated before, I'm a landlord. I do have some houses that are not the Taj Mahal. They are lesser quality houses, but we try to maintain them as best as we possibly can, and we try to make sure that the tenants are comfortable. But also with that, we're able to rent them at a discounted rate to these people. These people would probably not be able to rent anywhere else. But we make them comfortable, and we make the houses best they can. They're older houses, and probably in the next 10, 15 years, we'll tear them down and put something new up. If there's ever a problem with those facilities, we try to fix them and we try to make it as best we can. I'm going through the same process right now on my first rental property that I've had. My last tenant lived there for 30 years. And I hated to see her go, but she got married and he had a family. My little one-bedroom house was not quite big enough for everybody, but she loved that little house. She was a good tenant. And you know, she got behind several times in her rent. Sometimes it was just a month or a half a month, but I knew she would be good for it, so I kept her. And she would make up that rent. One time it was over the Christmas holidays. I forgave her rent because it was Christmas, and that's the right thing to do sometimes to good people. But, you know, LB 175 and the following amendments doesn't do anything for landlords that are honest and true. It does things to the landlords that are honest and true that we don't need. With that, I'd like to yield the rest of my time to Senator Jacobson, if he would have it.
Thank you, Senator Lowe. Senator Jacobson, you have 2 minutes, 35 seconds.
So do I owe you a favor, or how does this work? I'm trying to figure that part. Always. All right, great. Thank you. Well, let me just finish up where I kind of began before. And again, as we start thinking about what happens on the gaming of the system, and I always worry about this on any legislation that we pass, is when we start messing with the agreements that are out there. So we start messing with law, people enter into contracts with the current set of statutes that are in place. And then we start messing with the statutes, and all of a sudden it has a negative impact on the contracts that we've entered into. Because the way the bill is written now, this is retroactive, okay? This goes back to anyone who's had an eviction and had it stopped. And at the end of the day, I'm trying to figure out what the real problem is here, because landlords, at what point do I, as a banker, not have rights to your credit bureau? Or is everything going to be blocked that's bad on your credit bureau, so I have no way to know how to underwrite a loan? And if that happens, what's the default? The default is the person with a high credit score pays more, because I don't know that you have the high credit score. You might have someone with a low credit score, and I've got a likelihood of a loss because you're less likely to pay. If I went in to buy an insurance policy from an insurance agent, the insurance agent is going to ask me to fill out some information, and it's going to ask me, do you have have you been diagnosed with a terminal illness? And if you mark yes, they're probably going to underwrite the life insurance policy differently, which might mean they'll turn you down. And if you're not asked that question, you're not required to disclose it. How is that fair to the insurer, who is taking on a tremendous risk where you know something that they don't know? And this is part of the problem with this. We're sharing truthful information. We're not hiding misinformation. We're sharing truthful information. Thank you, Mr. President.
Thank you, Senator Jacobson. Seeing no one else in the queue, Senator Wayne, you're recognized to close on AM 2754.
Thank you, Mr. President. I am tempted to call the House just because I've missed this opportunity with nobody on the floor, but I won't, because I'm an exec right now and I'm gonna go back to exec. But here's what I would tell you, and I'm just saying this for the record. And when you say for the record, you act like you don't know what you're saying is actually going into the record, but it is going into the record. So everything you say is technically for the record. So kind of one of them pet peeves when people say, I just want this on the record. Well, when you're talking, you're on the record. So you don't have to say that you want this on the record, because it's already on the record. But I'm on the record, and so I want to say something for the record. And that is September or October, we will be here on a special session. So when you are thinking about your having the harvest and all that during that time, we're going to have 1,000 jury trials pending in Douglas County and Lancaster County and Sarpy County that we will not have a solution for. We will not have a solution for, and guess what, landowners? You won't get paid because there is no mechanism when you go to the jury or when they ask for a jury trial, which they are doing right now. Everybody in Douglas County, not everybody, 80% are asking for jury trials. So it's already working its way up to the Supreme Court. When it's ruled unconstitutional, I'm going to give July, August, September, October, we're going to be back here because there's going to be 1,000 property owners who have lobbyists out here in the hallway who are saying we're not getting any money and the courts are not doing anything about it. We got jury trials till December or going into next year. How do I know that? Because I have a jury trial that's a 2-day trial that I just scheduled for March of 2025. Odo County, I have a trial right now for August and September, which is a half a day of trial. So I am going to do what the introducer of this bill wants, which is withdraw my amendment. But mark my word, we will be here in a special session because there is going to be 1,000 families and 1,000 property owners who have no solution to what's going on because the Supreme Court is going to rule this provision unconstitutional. And we decided not to step up today. I withdraw my amendment. Thank you, Mr. President.
Thank you, Senator Wayne. Without objection, that's withdrawn. Mr. Clerk.
Mr. President, announcement. The Education Committee will have an executive session in room 2022 today at 3 o'clock. Education exec session today at 3 o'clock in room 2022. Some additional items, Mr. President. New A bill. Legislative Bill 1087A, introduced by Senator Jacobson. It's a bill for activating appropriations, appropriates funds to aid in the carrying out of the provisions of Legislative Bill 1087. Additionally, Legislative Bill 685A, introduced by Senator Lowe. It's a bill for an act relating to appropriations to appropriate funds to aid in the carrying out of the provisions of Legislative Bill 685. Amendments to be printed. Senator Reapy to LB 204A. New LR 317 from Senator Walls. That'll be laid over. As it concerns Legislative Bill 175, Mr. President, Senator Dungan would move to amend the committee amendments with AM 2908.
Senator Dungan, you're recognized to open on your amendment.
Thank you, Mr. President, and thank you to those who have been a part of this conversation and continue to listen in and work with me. Senator Wayne, I think, is absolutely right. We are going to have an issue on our hands. Unfortunately, today, based on conversations we had and based on all of the vote counting we did, there simply aren't the votes in this body to address the issue of whether or not we should reinstate the right to jury trial for evictions. And so what this amendment does, AM 2908, is it gets rid of the entire jury trial portion. So we're cutting out all of LB 1115, which I'm very disappointed about because we did work very, very hard up until now to figure out a proper way to make that all work. And frankly, I think we still need to do it. I'm not totally convinced we can't figure out another way to take care of that here in the near future. I'm going to keep working on it. I'm going to keep talking to my colleagues because I think there is some consensus that it's an important issue. I'm glad people are hearing about it now because I think we can come to some consensus. But AM 2908 effectively cuts out all of the jury trial portions. What it leaves in is two things: clean slate as limited to those who have never actually been evicted, like we were already talking about. But the major change that it makes, and this was done in discussion with landlords representatives, this was done in discussion with realtor representatives who both say they not only are neutral on this, but in fact support this amendment. It allows you to have clean slate relief one time. One time. And the reason for that is what we're trying to do is we're trying to capture those individuals that we've already talked about where due to potentially a lapse in payment or some sort of other catastrophic event happens, those individuals are unable to pay rent on time. And let's say that an eviction notice gets filed immediately and that gets filed and then they are able to pay their rent. They would be able to achieve clean slate relief on that eviction for that one time. If, however, they continue to be quote unquote bad actors and have these issues happen time and time again, they would not be eligible for clean slate relief. And so do I think this covers the entirety of the problem? No. Do I think that Senator Linehan and others have hit the nail on the head, that this is an issue that needs to be addressed in a broader capacity? Absolutely. But I really do think, based on the conversations that I've had, that this satiates the concerns of every single entity that came in and was in opposition to LB 175 originally. Because the opposition we had was from the landlords, and it was from, I believe, some realty companies, maybe some property management companies. But I have been working very diligently all day long to go talk to the interested parties to see whether or not this would be okay. And as I said, they have said it is fine. Senator Salama and I have spoken about it, and I am aware that this does not address all of her concerns, given that I think she had more concerns with the clean slate portion than she did the jury trial portion. But I do believe that AM 2908 is a consensus amendment amongst all of the interested parties, and I'm talking about landlords, tenants, advocate groups, everybody that I've been talking with diligently throughout the entire day, and I think that AM 2908 does address our concerns. In addition to that, AM 2908 contains a bill that was originally introduced by Senator Dover. That is a bill to allow for e-notice, so electronic notice, and e-communications between landlords and tenants. It effectively, as was explained to me, brings landlord-tenant relationships into the 21st century by allowing for email summons, email notice, and things such as that. It came out of the Committee 8-0. It was something that was supported across the board. And my understanding is it is something that both the landlords and the tenants want. And so we decided to add that in there because I think that makes this even more of a consensus bill. So again, colleagues, I would appreciate your support in AM 2908. We've been working diligently to try to come to some conclusion. I'm hopeful that maybe Senator Slama and I can work something out moving forward. But I anticipate we will hear a little bit more about whether or not she is in support of this amendment. Thank you, Mr. President.
Senator Slama, you're recognized to speak.
Thank you, Mr. President, and good afternoon, colleagues. So I took a moment because we've got pages on the floor, and God love them. Like, there are 10 people on the floor right now, and they're intent and paying attention. And I had one of the pages come up to me earlier in the session and go, like, my job's just to get like water and coffee. No, your job is to learn as much about politics as you possibly can, and God willing, you learn enough to run away from it as fast as humanly possible. I tried to explain what was going on here because I see two diverging paths here of debate, and I'm just curious as to where we veered off and failed to communicate. In that, with this amendment, we're getting rid of the LB 1115 language, which I said, if you narrow it to where we can address the Supreme Court's issues and you leave out the language on LB 175, so if you replace the language of LB 175 with narrowed language on LB 1115, so that we can prevent the world from ending with a Supreme Court decision ruling landlord-tenant law unconstitutional, so we don't have a special session where all the Democrats are running around going, I told you so, I told you so. The Supreme Court came at Landlord-Tenant Act with an Uzi. But now we have an amendment on the board that restores the language of LB 175, eliminates the thing that we evidently have a constitutional crisis over, and we're pretending like it shifts votes. It doesn't shift votes. I don't care if you were out in the lobby discussing it with the landlords and the realtors. The lobbyists don't have a vote in here. The senators who are elected do. And not one of the senators who has expressed concern over this issue has expressed, oh, LB 175 isn't my problem, it's the jury trial that's the problem. We're sitting here going, my God, there's a constitutional crisis, and we're willing to be bipartisan about this, thoughtful about it, and address this issue. But here we are with an amendment going, never mind. I guess the constitutional problem wasn't as big of a deal as we thought. So now we're narrowing LB 175 by giving it a one-strike rule, which I'm opposed to, because once again, how do you have that work if the record's sealed? And it gets to the core of, again, this is a big government bill that I'm going to take 8 hours on, but I've been very clear about what I'm asking for and about what small government conservatives are asking for. It's not just, oh, do I agree? It's, I am making what a large number of other senators are making very clear to me, very clear on the mic to Nebraskans, to Senator Dungan, in that we're willing to talk if we're getting rid of like the constitutional crisis that's going to keep Justice Papik, and this is nothing against Justice Papik, up at night. Like, cool, we're game for that. But if we're going to do this whack-a-mole of, oh, well, the landlords and the realtor said the jury trial thing was a problem. Okay, well, then evidently this constitutional crisis wasn't as big of a deal as we thought, so we should probably just kill LB 175. So, like, now I'm just sitting here going, well, I'm going to talk this thing to 5 because clearly the message isn't getting across, and I can just read all of the stuff that we've put together for me filibustering this because clearly we've diverged. We've gotten to a point where there's clearly somebody on the lobby trying to undercut this negotiation and a disinterest in actually addressing what we're claiming is the real problem and the need to pass LB 175.
1 minute.
So I'm sitting up here going, okay, red vote all of it because clearly we're not going to come to an agreement. Clearly this doesn't have 33 votes. If we want to take it to a test vote, that's fine, but I want to make it abundantly obvious that nobody's changing their minds based on the language for LB 1115 getting eliminated. That's actually what was going to bring people on board because of the supposed constitutional crisis that just isn't going to happen now. So what I'm going to do is sit back, wait for us to take a vote on this, vote probably present not voting, file a motion to reconsider, and then go through all the motions that I was talking about to take us to 5 o'clock to where maybe if we sleep on it, we can come to a logical conclusion. Thank you, Mr. President.
Seeing no one left in the queue, Senator Dungan, you are recognized to close on AM 2908.
The House.
There has been a request to place the House under call. The question is, shall the House go under call? All those in favor vote aye. All those opposed vote nay. Mr. Clerk, please record.
9 ayes, 5 nays, place House under call, Mr. President.
The House is under call. Senators, please record your presence. Those unexcused senators outside the chamber, please return to the chamber and record your presence. All unauthorized personnel, please leave the floor. The House is under call. Senator Dungan, you are recognized to continue with your close.
I can wait also, can't I? Until people, I can, okay. So I will start closing, but I will probably end up repeating myself as we get more and more people in the room. Colleagues, what you're voting on here, AM 2908, is an amendment that was worked out that pares down the original bill that we were talking about earlier today. So originally, the whole process and what we were going with here was LB 175 was being amended in order to include the restoration of the right to a jury trial for eviction actions. And so had that have been successful, what we would have wound up with between LB 175 and LB 1115 was a combination bill which Senator DeBoer prioritized because she understood the importance of trying to figure out this issue before the Supreme Court gets there. Senator Wayne, I think, did a very good job of articulating what the problem is going to be if and when the Supreme Court reaches a decision saying our current landlord-tenant statute is unconstitutional. And so we were trying to address that. We were trying to get ahead of that and make sure it wasn't a problem. Unfortunately, we ran vote cards today and the votes simply weren't there. And so, you know, to push back, I guess, gently and respectfully on the idea that, oh, I guess it's not actually that big of a deal. No, it's an incredibly important deal. It's a very, very big deal, but there weren't enough votes in this body to actually get there. And what's been tricky, and I think one of the predicaments we've run into time and time again is with these bills, I was talking to people and not actually getting a clear idea or answer as to what their issues were with it. In addition to that, we have a bill, 2 bills rather, that came out of Judiciary 8-0. So part of the reason I think this was scheduled when it was is I don't think we anticipated there being quite this much pushback, because when these came out of the Judiciary Committee, they were unanimous because we had worked very hard to come to some common sense solutions on these problems. That's a problem that we weren't able to come to that same solution today. But ultimately, over the lunch hour, I'd met with a number of individuals, senators included, talking about what their issues were with the bill. And a number of senators told me their issue, again, to push back on what Senator Slama just said, a number of senators indicated to me that their problem was the right to the jury trial portion because they didn't know how it was going to work. They had questions about it. There was a lot of hesitation. And so ultimately, what we decided is that we would take out the right to a jury trial portion and just have the clean slate portion. In addition to that, yet again, demonstrating my willingness to continue to pare down this bill, we did so even further. So what is currently in AM 2908 is two things. One, it is a clean slate provision where if an individual is never actually evicted or doesn't have an eviction action against them perfected or come to an actual adjudication or disposition rather, then they would have clean slate relief or they could apply for clean slate relief, meaning that it would be taken off their record. We limit that further in AM 2908 to one time. One time. They can get clean slate relief. And that is intended to capture those individuals who had something bad happen and unfortunately had an eviction action against them brought, and then they settled the issues. We don't want that to follow them forever. But 2908 makes it so you only get that relief one time. If you are a continuous bad actor, and if you continue to have evictions filed on you time and time again, then those still show up in your history. So we talked with the landlords, we talked with
One minute.
Thank you, Mr. President. We talked with the landlords, we talked with the realtors, not just their special interest, but because they are the only ones that came in opposition to this bill. And they said they're not only neutral on it, they are supportive. They support AM 2908 being attached into LB 175. So colleagues, please, 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 when you're voting for AM 2908, know that it is the culmination of a lot of work. It is the culmination of a lot of conversations from people across the entire spectrum. It represents a true compromise amendment. And please do not let the disdain of one person about this bill deviate you from the fact that this came out 8-0. And also, by the way, includes, I apologize, I forgot to mention again, a Senator Dover bill that also came out 8-0, allowing for electronic notice between landlords and tenants. So consensus bill, I don't see any opposition that has continued to come in from the people who this actually affects, and I would encourage your green vote on AM 2908.
Thank you, Senator Dungan. See no one else in the queue. You're recognized to close on the amendment. Okay. Members, the question is the adoption of AM 2908. All those in favor vote aye. All those opposed vote nay. Record, Mr. Clerk.
32 ayes, 11 nays, Mr. President, on adoption of the amendment.
The amendment is adopted. I raise the call. Mr. Clerk.
Mr. President, Senator Slama would move to reconsider the vote just taken on AM 2908.
Senator Slama, you're recognized to open on the motion.
So as promised, I outlined exactly what would happen. I don't have any disdain. I don't approach any kind of bill debate with any kind of disdain. So claiming that I have disdain is inaccurate because I have no feelings on this. I just don't like big government, and this is a big government bill. We're still in a position now with LB 175 where we have all the big government parts that people didn't like. Everyone who was on the fence with this bill in the morning told me, you know what, 175 itself is a problem, but we're willing to deal with it if we can get the LB 1115 jury trial language on, because there's a Supreme Court decision in which they reference problems with right to a jury trial when it comes to evictions. Okay. Well, I made it clear that that was a thing that we were willing to negotiate. So I brought this motion to reconsider because we've now eliminated that part of LB 1115 that we talked about just having to add. Otherwise, the Supreme Court was going to rule all landlord-tenant law with all the ag leases and all the rentals unconstitutional. And so we're back to the baseline bill, LB 175, which prevents another landlord from asking a landlord on a background check as to whether or not they evicted a tenant. Here's why that's important. Let's imagine for a second that we have a tenant in a property that's not paid rent, that's cooking meth, whatever. Like, there's so many different options you can do. In rural Nebraska, it looks different than in Omaha, I'm sure. Common problem we have, tenant not paying rent and tenant not upkeeping the premises. Let's just say they're cooking meth on the kitchen stove. It does happen. Ask any of the rural landlords on the floor. It happens more often than you'd like. You go through the 2-week mandatory waiting period before you can serve an eviction notice on them. All right. So you file the eviction notice, you pay for a lawyer to file the eviction action, and before your hearing date, the person cooking meth in your house, a few weeks down the road, and they've now had a month and a half of basically free reign over your premises. They take their stuff the night before the hearing and they get out. So you, as a landlord, don't have anyone to evict anymore. Your eviction action is dismissed. The person has cleared the premises. You're now out a month and a half worth of rent. You have damages that you're never going to get because the person skipped town, and you also have lawyer fees. So landlord number one is left holding the bag. Tenant one, cooking meth, late on rent, hangs out for a month and a half in your property for free, is now trying to rent another property. This landlord, the second landlord, landlord number two, is now looking into this tenant's rental history. Nothing comes up. That's weird. You reach out to the landlord. Landlord one, who was stuck with a month and a half of no rent and a lot of damage to his place. Landlord number two asks landlord number one, well, did you evict tenant one that was so terrible that supposedly caused all this damage to your house? You can't even say that you filed an eviction action against them. What we're doing right now with this bill is subsidizing, forced subsidization by the government of landlords for bad actors. Like, we're not sitting here going, these tenants at 12:30, 30 minutes past midnight on the day that they were supposed to pay rent, are getting eviction actions filed against them. You file these actions when you've hired a lawyer, when you're willing to pay court costs. It's not something that's to be taken lightly, and it's not something that's spuriously filed. And we've had examples brought of bad actors. There are bad actors, landlords and tenants. There's inequality in our justice system, especially on the civil side. I'll be the first to admit that, and I will be the first to say that things like the Tenant Assistance Program are wonderful things that help fill the gap in our justice system. However, when we have legislation like LB 175, it's big government that ties the hands of landlords, that prevents other landlords from finding out bad actors before they get on their property. So no, I don't have disdain with this bill. I don't have really much feeling for it at all, other than it's big government. I've told everybody what I was going to do. I didn't want it to get to this point. I don't know where we got off the rails in terms of negotiating where we were going to go and why. But now we're sitting here with a bill that's going to go until 5 o'clock. Ideally, Senator Dungan's going to have the night to think about it. I'm guessing we have a veto override scheduled for tomorrow, to where ideally we have some time to circle the wagons and make this a better bill. Because at the end of the day, what we're looking at here is a bill that, yes, it's been parsed down. We now say one strike. You get one freebie. You get one rental property that you get to destroy. And we don't get to talk about it. Next year, it'll be the 3-strike rule. And then the year after that, it'll be the 3-year automatic erasure of any eviction notice that you get. And then we'll have a bill like New York and California has now, where the landlord can't even look into your criminal history with certain misdemeanors and felonies. It's a clear, slippery slope that we're going down. And I'm not going to vote for it. And I'm going to do everything in my power to support small government, support the people who try to make housing affordable in our state and housing available in our state by offering it to tenants, by blocking this bill. I made it clear that I'm very concerned about the constitutional issue. I'm all for working together with Senator Dungan to avoid a special session. I think Senator Wayne has been really operating in good faith when he's also been dealing with a bunch of executive sessions of his own doing, admittedly, in the Judiciary Committee. And I'm unclear as to why we're sitting at this point today, after having argued for most of the day that we're facing a constitutional crisis if LB 1115 doesn't get attached to LB 175, now going, meh, it's not that big of a deal, I guess. So at the end of the day, no, I don't have disdain. No, I don't have feelings. I made it very clear what I was going to do at the start and where my negotiating point was. That didn't follow through. So now I'm following through with what I said I would do. I will file a reconsider here and a bracket and an amendment and a reconsider on all of those things. We'll take it 8 hours. I didn't want to have to get it to this point. It'll need 33. Because I'm not going to let this slippery slope start sliding when it comes to landlord and tenant law in Nebraska, because I've seen in New York and California where this goes. And I'm going to stand here and be really annoying about a bill that Senator Dungan is going to say is no big deal, because it is a big deal. It's the first step in being a really big deal and cutting into the availability of affordable housing in our state. So I'm not going to be here next year. Thank you, Mr. President. I'm not going to be here next year for the slippery slope, step 2, of bringing back unlimited bites at the apple in terms of if the case is dismissed and the tenant moves out a month and a half the night before the hearing. I'm not going to be here 2 years down the road when we have unlimited clean slate tenant law, so long as you're 3 years out from your last eviction. And I'm not going to be here the year after that when now suddenly you can't consider criminal records when it comes to renting out your property. I'm all for private property rights. I'm making a stand for private property rights today. I don't care if it goes 8 hours. I'm fine with that. I have the time, I have the binder, and I'm ready to go. Thank you, Mr. President.
Thank you, Senator Slama. Senator Hansen, you're recognized to speak.
Thank you, Mr. President. I was just going to ask a question of Senator Slama that she can expound on. I do respect her opinion on matters such as this. She has more experience than me in matters of legalities when it comes to tenant law. And so I'm hoping, because I want to make sure I'm not missing something with the amendment and with what your concerns are. Can you expound maybe just a little bit more on the big government aspect that you were talking about before?
Senators.
If Senator Slama will actually, I'll yield the rest of my time to Senator Slama to answer that question.
Thank you, Senator Hansen. Senator Slama, you have 4 minutes, 13 seconds.
Thank you, Mr. President, and thank you, Senator Hansen. No, I appreciate that, and I think we're both on the floor as small government conservatives here. And the problem with LB 175 from a big government versus small government perspective is we are getting government involved in the landlord-tenant relationship and blocking potential landlords' view from tenant misconduct. So backing up to square one with LB 175, how it operates and the problems therein. And I'll start off with saying I'm grateful for Senator Linehan and her speech when I was on Judiciary Committee and it was 7-1 and then 6-2. Like, it was hard, and I get it. And I have all the respect in the world for the Judiciary Committee. However, just because a bill comes out of committee doesn't mean it's ready for prime time, doesn't mean it's ready to go. But from a big government perspective, we are saying that tenants' misconduct is entirely excused so long as the eviction action is dismissed before it gets to its hearing date. And we're only giving them one bite at the apple. We're only giving them one time to destroy the property or cook meth or not pay rent or try to be squatters at the property at which they're renting. And my big problem with that is it's just another erosion of private property rights when it comes to the landlord-tenant relationship. We're saying you get one freebie that you can't ask as the new landlord for this tenant. You can't ask, you cannot see, you can't even consider if this person had an eviction action filed against them, if it was dismissed, if it didn't follow through the multi-week, sometimes multi-month process of evicting them from the property. You get one freebie. And that's a problem. That's a bad precedent to be setting in the state of Nebraska, to go, you can't look, you can't ask. It's like going to a bank and asking to take out a loan and having the bank be unable to see that you filed for bankruptcy when you apply for a loan. It's the same idea. For me, sunlight is the best sanitizer. And I have a really big problem with bills like this, where we say, oh, it's big government, but it's a small big government bill. Because what we're doing is incrementalism. We're trying to make something palatable, just enough so that a senator who believes in private property rights, believes in small government, doesn't take it 8 hours. We're just trying to make it palatable enough to where it just seems unreasonable to take 8 hours of time on it. And then next year, we'll have another little bill that says, so long as the eviction action was dismissed, you get unlimited bites at the apple. And we'll say that that's no big deal too.
1 minute.
Because, thank you, Mr. President, because who's going to be willing to take that 8 hours? And it's incrementalist big government policies that erode private property rights, that erode our liberties. So I'm sitting back as a small government enthusiast going, no, I'm not going to let that happen, because I'm on my way out. And you know what? I'll be that person who raises my hand and stands in the way of private property rights being eroded in our state. I will be that person. Like, this will go the full 14 hours. If he ends up getting 33 votes, fine. But there has to be somebody standing up for private property rights and the availability of affordable housing in the state, and I'll be that person. Thank you, Mr. President.
Thank you, Senator. Senator Lowe, you're next in the queue.
This lady,
Thank you, Lieutenant Governor, and thank you, Senator Slama, and thank you, Senator Hansen. You know, here we are. This is the reason why I came down here, to try to stop government from taking over little bits at a time, little nibbles away at our freedoms. And that's what this bill does. Takes away just a little bit of our freedom, we won't notice it. Ask the frog you put in a cold water and then turn the heat up. He doesn't notice before it starts to boil. That's not a pretty sight. But here we are with maybe 9, 10 people on the floor. The ice cream downstairs must be pretty tasty. You know, as we look at this, as a landlord, I look at my freedoms to rent a house to who I want to. And when I don't know if that person has committed crimes or anything else, I don't know what's going to happen in that house. I think I deserve to know, because I don't need that house laying empty any longer than I need to after I have to go back in and fix it up after I get a tenant who has destroyed it. That costs me money that I have to borrow from the bank. Because even though I own these, the real owner is the bank, and the bank owns them. Well, actually, it's probably the state owns them because we owe high property taxes in Nebraska, and I have to pay the property tax that is extremely high. It's based on the sale of property around me, even though it's not comparable. I have 2 buildings in downtown Kearney that sit next to another building. I value my 2 buildings at $150,000 a piece, which is more than I paid for them and what I believe I can sell them for. But they have a buyer that's willing to pay $325,000 for the building that's right next to mine. Guess what my buildings are going to be valued at next year on my taxes? Not $150,000, not $185,000, but they will be valued at over $350,000 because the building next to my 2 buildings isn't as large as my 2 buildings. So my taxes are going to go up. What happens when that happens? My tenants are going to get a raise. They're going to get an exorbitant raise because their leases aren't due for another 2 years. And I have to eat those taxes for 2 years. So I've got to make up time once I do renew the lease. And I'm very sorry for those tenants because it's not my choice to raise their leases. This will also occur with houses, with apartments that we have. Because now we have to rent, or now that we rent to tenants that we don't know who they really are or what they've done to other apartments, we don't know what's going to happen to these apartments, and so we have to raise our rents on all the apartments. Why? Because we pass LB
1 minute.
175. Thank you, Lieutenant Governor. And we don't need to. We don't need to do this. This is not helping at all, especially those in the lower income, because they will take the brunt of it, because they can't afford anything nicer than what they're living in. They're not living in some place with a 2-car garage attached on. They're living in a place where they may still have to park on the street or just park off the street without a garage. It is these tenants that this will affect. And I'm sorry for them if we pass this bill. Thank you, Lieutenant Governor.
Thank you, Senator Lowe. Senator Slama, you're recognized to speak.
Thank you, Mr. President, and thank you, Senator Lowe, for outlining your concerns about this bill. So the first thing I'm going to read is, again, I think there's a lot of unfamiliarity with this process and what it looks like. So I'm going to read from the Lancaster County webpage the eviction process. One of the most frequently asked about civil procedures is the eviction process. The information contained on this page is for informational use only. For detailed information or legal advice, please contact an attorney or research the references provided at the end of this article. Legal eviction in Nebraska must be accomplished through a civil court lawsuit of forcible entry and detainer filed by the plaintiff/landlord versus the tenant that is to be evicted. The sheriff's office role in the lawsuit is through the service of 3 different types of civil process generated by the procedure. Services the sheriff's office provides in the eviction process are listed below in their respective order. 1, notice to quit. The first step is for a plaintiff/landlord to provide a written notice demanding the tenants vacate the property. The plaintiff will prepare a document referred to as a, quote, notice to quit, end quote, and may choose to have the sheriff's office serve this writ. There are no statutes that dictate a particular type of service or return day for a notice to quit. The sheriff's office policy is to attempt service as soon as practical, and service can be either personal, residential, or may be accomplished by posting the notice on the door of the residence. The sheriff's office does not provide forms for these notices nor give advice as to their content. The notice to quit is not, and this is in all caps, not a court document and does not order removal of the occupants. It's simply a notice for the tenant to vacate the property by a specific date, or the case will be taken to the court for eviction. After the service of a notice to quit, should the tenant fail to move, the plaintiff must then commence suit in a court with jurisdiction in order to proceed. 2, summons of forcible entry. A summons, a notice of the suit, may be sent to the sheriff's civil division for service. The summons contains a time and date for trial and must be returned to the court within 3 days of its issuance. Service of the summons may be personal or residential. 3, writ of restitution. If the landlord prevails at trial and is awarded judgment, a writ of restitution may be issued. A writ of restitution orders the sheriff to remove the defendant and restore the premises to the plaintiff in the procedure described below. A writ of restitution must be executed and returned to court within 10 days of issuance. Because of this relatively narrow window, it will be executed without delay. To expedite the process, the plaintiff should provide a contact name and phone number for their representative. LSO, writ of restitution service, eviction procedures. Unless some other type of action is specified in the writ of restitution, service will be executed as follows. Deputies will contact the plaintiff, plaintiff's attorney, or authorized agent to set up a time/date for restoring the premises to the plaintiff. The sheriff's office requires the plaintiff or their authorized agent to take possession of the premises.
1 minute.
Thank you, Mr. President. At the time of the eviction, should the plaintiff choose to change the locks on the residence, the sheriff's office is not obligated to stand by while the residence is being secured. Deputies will serve the defendant's copy by personal, residential, or posting. An additional notice from the sheriff's office will be served/posted indicating that the residents have a specific time frame to vacate the property. I'll continue reading this on my next turn on the mic. Thank you, Mr. President.
Thank you, Senator Slama. Senator Bostoman, you're recognized to speak.
Thank you, Mr. President. I do have some questions about the unconstitutionality of the case we're talking about. I believe it's NP Dodge case that we're talking about that the court had. And I'd asked Senator Slama if she would be available to answer some questions, help me understand a little bit better. Would Senator Slama yield to some questions?
Senator Slama, would you yield to some questions?
Yes, sir.
So is the court, it is in the NP Dodge case, and did it not rule that it is unconstitutional?
So, and I appreciate you asking that question, Senator Bosselman, because the ruling that was being referenced as to the need for LB 1115, which is just magically dissipated now after the lunch hour, was that there was a concurring opinion that alluded to if the right to trial was not clarified in the Landlord-Tenant Act, that entire section might be rendered unconstitutional. So that was the concern that was being raised as to the need for LB 1115, and that we needed to tighten and clarify our language when it came to right to a trial by jury with the landlord-tenant statutes for our state.
So that was based on one justice that in a concurrent opinion speculated that it may be?
Yes, that was the concurring opinion of Justice Papik in this particular case.
Okay, I don't believe that has been a case that has been appealed to the appeals court with this.
So I'm not familiar with the entire docket. Senator Wayne has made reference to this, and I trust his word on this, in that there are some cases that might be on point when it comes to this particular issue on appeal. I'm not familiar with those specific cases, but if he's claiming that there could be cases on point that might be appealable, that might lead us to a special session in September, should the court rule very, very, very broadly when it comes to our landlord-tenant statutes. I mean, Senator Wayne is a qualified, competent attorney who practices in this area. So I'd have to say that there's likely something that at least gets within spitting distance of the constitutionality of the right to a trial by jury in our landlord-tenant acts.
Okay, I believe the Attorney General has filed a brief in the NP Dodge case defending the constitutionality of Nebraska's Residential Landlord-Tenant Act. Do you know about that?
I don't, and I'll put a pin in this, that if I do find that opinion, I'll read it aloud on the mic, just for the sake of getting it into the record. As Senator Wayne referenced, anything you say on the record is in the record. You don't have to say it's on the record because it's automatically on the record. But I have heard of that opinion, and I definitely would like to get that into the record if given a chance.
Okay, thank you, Senator Slama. I appreciate the opportunity to have to ask questions, Senator Slama, and have some more clarification for myself, specifically to the MP Dodge case. I'll see if I can't find that brief myself and look it up. So thank you. I yield the rest of my time back to the chair.
Thank you, Senator Bostoman. Senator Slama, you're next in the queue, and this is your last time before your close on the motion to reconsider.
Thank you, Mr. President, and good afternoon again, colleagues. I'm grateful for Senator Bosselman's questions when it comes to the MP Dodge case, because that was the entire urgency surrounding LB 175 this morning, right? Oh my God, there's this unconstitutional provision of the Landlord-Tenant Act when it comes to right to a trial by jury that we need to address in LB 1115. Otherwise, we're all going to get pulled in from harvest come September, because we're just going to have a mess of right to trial by jury eviction cases, because all of our landlord-tenant statutes will be ruled unconstitutional. Well, we've now abandoned LB 1115 entirely. We've said, we don't have the votes. And I've been very clear that I'm more than willing to address this issue in a bipartisan, narrow fashion to clarify any language that we may need to address referencing that concurring opinion in NP Dodge to ensure that we're not sitting here in a special session. But LB 175 has now eliminated any reference to 1115, and it's simply you get one free shot as a tenant of destroying a property and getting evicted and going through that process, and your next landlord can't ask your old landlord about it. So I'm now taking time speaking out about the erosion of property rights. Oh, thank you. Okay, again, shout out to my staff. I was literally just handed the case, the AG's opinion, everything I need. So on my next turn on the mic, we'll explore this. Shout out to my wonderful office staff. They keep me functioning, and I'm so grateful for them. They are rock stars. But I will get back to the eviction process, because I do think people are under the impression that this is somehow a quick process, that if somebody fails to pay their rent, by the time they wake up at 7:30 the next morning, they'll have all their stuff thrown outside in the yard. The locks will have been changed in their sleep. That's just not what this process looks like. It is a very long, arduous process where landlords already have to jump through hoops in order to get somebody who's not paying rent, breaking the law, destroying the property. One senator brought up that sex trafficking is a problem in some of their rental units in their district. I'm not going to reveal who that was because I want them to be able to share that experience on their own. But it's not an overnight process. And landlords are left jumping through these hoops. So this is just from the Lancaster County webpage about what the process for eviction looks like. And we have to go through 3 stages. We've already discussed them: notice to quit, summons of forcible entry, writ of restitution. So right now we're talking about the writ of restitution. So we get through all the notices, it gets to its hearing date, and the judge goes, yep, you're evicted. You're you're off the premises. You have to do it within 10 days of the judgment. So we've already had the hearing in court. We've provided all the notice. The day has come. So by sheriff's office policy, 3 days notice is given whenever reasonably possible to allow the defendant time to voluntarily vacate the premises and remove their personal property. This time frame also aids the plaintiff from having to dispose of property under the Disposition of Personal Property Landlord and Tenant Act. Thank you, Mr. President. Generally, the sheriff's office will not execute writs of restitution at night or on weekends or holidays. At the time of the eviction, the deputy will arrive at the location and remove any occupants from the premises if necessary. Occupants will be advised of trespassing violations they could be subject to if they return. Tenants with personal property remaining in the residence must contact the plaintiff to arrange for removal. Provisions for such are set out in the Disposition of Personal Property Landlord and Tenant Act. Deputies will not take part in the disposal or removal of personal property unless specifically ordered by the court. And I will take this up once I'm through talking through the AG's opinion, the MP Dodge case, through talking about that. But I do want to revisit this in future turns on the mic, and I've got the time to do it. So thank you, Mr. President.
Thank you, Senator Slama. Senator Lowe, you're recognized to speak.
Thank you, Mr. President. As I look outside, it seems to be getting a little darker out there. And so we must be going into late afternoon. And as we discuss LB 175, and as I'm looking at my computer, I'm following along the University of Nebraska women's basketball team, who is working out trying to get into the Elite Eight down in Kansas City at this moment. And that is why if you went outside, you saw little Herbie out there and the bull from Omaha, but you did not see Louis the Loper. Louis the Loper is an antelope, and he is now down at the MIAA women's basketball tournament, and UNK is leading Washburn 65-58 with 6 minutes left in the fourth quarter. Just an update on sports as we go along today, a little different. I am still against LB 175 and what it does to the tenants. You know, we don't think about the tenants when we're discussing this as a landlord bill. And so it really goes against the lower income tenants. I think we need to think about that because as we go on as landlords, we have to look about who we're going to rent to. And do we switch everything to higher end apartments and get rid of our lower end apartments by bulldozing them down and putting up a nice apartment that will bring in much more money? Or do we be kind and rent to those people that we really need in our communities to run our businesses? And I mean by run them, they're the ones that take care of our businesses. They're the ones that clean the floors. They're the ones that wash the windows. They're the ones at the teller's office or teller's booth at the banks. They're the ones that are waiting our tables for us. They're the ones that do the work for others. Most of them, if they do live in a higher end apartment, they live 4 or 5 people to an apartment just so they can afford the rent. Or they could rent a little lower class place, one that may not have the best looking paint, but it is painted at a reasonable rate. I'd like to yield the rest of my time back to Senator Slama before I jump back in the queue, and I'll give you another report on the basketball game. Thank you.
Thank you, Senator Lowe. Senator Slama, you have 2 minutes.
Thank you, Mr. President, and thank you very much, Senator Lowe. I do think very highly of the University of Nebraska at Kearney, and I am specifically appreciative that they're smart in their budget and that they only have one Louis the Loper, and that he is choosing, instead of hobnobbing with senators, to go support the women's basketball team. And I think that's awesome. Another sports shout out, Peru State men's basketball team got to play spoiler and won their conference tournament for a berth into the NAIA national tournament this weekend. It was a big upset over Baker. And those guys have worked for years and years to get a berth in the NAIA tourney. It's huge. And moreover, so Peru State is in Nemaha County. Thank you, Mr. President. And this weekend, we're also going into the boys state basketball tournament. There are three, I'm so sorry, undefeated teams left in boys high school basketball in all classes statewide. 2 out of those 3 are Johnson Brock and Auburn High School, also in Nemaha County. For those who are unaware, Nemaha County is in District 1. I'm a proud graduate of Auburn High School. And you know what? I guess Nemaha County and District 1 are the basketball capital of the state. And I'm very proud to represent them and all of District 1. So go Bulldogs, go Eagles, and go Bobcats. Thank you, Mr. President.
Thank you, Senator Slama. Senator Lowe, you're recognized to speak, and this is your 3rd opportunity on the motion.
Thank you, Lieutenant Governor. And it's getting close. It's now 67-60 against Washburn with 4 minutes left. I would like to yield the rest of my time to Senator Slama if she would like to have it.
Thank you, Senator Lowe. Senator Slama, that's 4 minutes, 35 seconds.
Thank you very much, Mr. President, and thank you very much, Senator Lowe. I am grateful for this chance to stand up for private property rights, and I am so grateful for the conservatives, the small government conservatives on the floor who are with me on this fight and are on the floor listening. Something I'm worried about is there's a decent number of people who I think were kind of sold a bill of goods in the closing for the last amendment, who weren't necessarily on the floor. They were in exec hearings, but they weren't following along with the issues inherent with the bill. So we're going to take some extra time so that we can kind of socialize the issues with this bill, the erosion of private property rights. And again, I've got the MP Dodge Holcomb case, and I do have the amicus brief from the AG's office for this case. So I am going to start reading that. But before I do that, I am going to finish the eviction process from the Lancaster County webpage, because it is valuable that those who are unfamiliar with the landlord-tenant relationship understand that when things go wrong, the landlord already has to jump through hoops that take weeks at a minimum in order to evict a bad actor tenant from their premises. And they have very limited options when it comes to seeking restitution from the destruction of premises. If it gets to the, especially if it gets to the point in court where they followed through with the eviction proceeding, they've already hired a lawyer, they followed through with all the notices they have to pay through the sheriff's office. So we'll get back to that and finish it, and then I'll get into the amicus brief. So whenever deputies have removed occupants from a premises, they shall supply the occupant with a short period of time to obtain vital personal effects or obtain such effects for the occupant. Deputies will take action to protect the person removed if necessary due to age, infirmity, mental or emotional condition, illness, or disability as provided by the law. If the premises involved are rental properties such as a house or an apartment, and the premises have been turned over to the plaintiff, the deputy has no further obligation. If the writ of restitution is for a mobile home owned by the defendant, the mobile home may be levied and set for the sheriff's auction. Keys, if available, for the mobile home will remain with the landowner in the event that the emergency entry needs to be made during the time prior to the sale. If the auction sale of mobile homes, a bill of sale issued by the sheriff only reflects the transfer of the defendant's interest in the property and is not an implied or actual title to the property. All actions take place in the exit vestibule of the Justice and Law Enforcement Center, 575 South 10th Street, Lincoln, Nebraska 68508. All services by the sheriff's office require a prepaid deposit before service will be attempted. Deposits for eviction services are, and this is to note that all of these fees are on top of your court filing fees, any lawyer you have to hire to file this action for you, any damage to your premises.
1 minute.
Thank you, Mr. President. You have to file this notice to quit yourself. It's not a standard form that you have. You have to have a lawyer draft it for you, or you draft it yourself, but it has to be upheld by the court. So we've got a $25 for notice to quit, summons, or writ of restitution within Lincoln City limits. $50 notice to quit, summons, or writ of restitution outside Lincoln City limits and within Lancaster County. But wait, if you're in a mobile home levied for a sheriff's sale, you have to pay $150 for a writ of restitution on mobile homes levied for sheriff's sale. So I'm really hoping that anybody following along understands that this process is lengthy for a landlord, it's expensive for a landlord, they're not going into this spuriously, and it's a process that requires a lot of different levels of consideration. So when we're talking about further limiting their rights, that's a problem for me. Thank you, Mr. President.
Thank you, Senator. Senator Clemens, you're recognized to speak.
Thank you, Mr. President. As a banker, I'm concerned about being able to look up the credit records of people, of loan applicants, and I am concerned about expunging a late payment or non-payment record from a person's credit history. And I would like to ask, would Senator Slama yield to a question?
Senator Slama, would you yield to a question?
Yes.
Thank you, Senator Slama. I was talking about bank credit reports that we gather when we have a loan application. And if a non-payment by a landlord, I'm sure, can file a credit report as far as non-payment if they experience that. But if this bill would pass, would that report go on file? Do you know?
So I think that's an interesting gray area, Senator Clemens, in that if the person was evicted for non-payment of rent, no, that's actually a fascinating question, because if you look at the language of LB 175, everything is sealed. So if the tenant is evicted for non-payment of rent, no one's able to access those records so long as you don't get to the follow-through of the final writ of restitution. So if we're talking about a tenant who was evicted for non-payment of rent, had to go all the way through the process, and the court has ruled against them, ruled for a writ of restitution. So we've already gotten through the several weeks, past the court date, past 10 days for the writ of restitution, and they get their stuff before the sheriff's office shows up. No, I actually think those records would be sealed and the banks would be unable to locate those records.
And then the landlord would be prevented from putting an eviction record on the credit report, I assume.
Yes, as I understand it, that's all sealed.
Right, well, that's a concern to me. In banking, we do look at people's history and other places where they have had credit or payments, and I don't support this bill for that reason, and I would yield the rest of my time to Senator Slama.
Thank you, Senator Clemens. Senator Slama, you have 2 minutes and 15 seconds.
Thank you, Mr. President. And I would like to dig into the AG's opinion. Well, it's an amicus brief on MP Dodge versus Holcomb. And this was under the last administration. It was AG Peterson that filed this. But just starting with all of these briefs, you have a very well-written table of contents. Some attorney at the AG's office puts a ton of effort into this. It's like a law school final project for a lot of these guys. So we get to page 7 before we get to the start of the brief itself. And it starts off with summary of argument. The county court did not err in denying Holcomb's request for a jury trial in this landlord-tenant possessory action brought under the Uniform Residential Landlord and Tenant Act, URLTA. The right to a jury trial protected by Article 1, Section 6 of the Nebraska Constitution does not attach to landlord-tenant possessory actions under URLTA because they are summary in process, equitable in nature, and substantively distinct from, thank you, Mr. President, from 1875 ejectment and FED actions in Nebraska. So let me repeat that because I think it's a key paragraph. That is, we were talking about LB 1115 and how that worked and the issue inherent in whether or not you get a jury trial in the landlord-tenant relationship in the state of Nebraska. We have this amicus brief of the right to a jury trial protected by Article 1, Section 6 of the Nebraska Constitution does not attach to landlord-tenant possessory actions under the URLTA because they are summary in process, equitable in nature, and substantively distinct from 1875 ejectment and FED actions in Nebraska. So we've got this amicus brief that I didn't anticipate getting into today that very clearly outlines why LB 1115 didn't have any constitutional issues with it whatsoever. We'll explore that more in my next turn on the
That's
mic.
your time.
Thank you, Mr. President.
Thank you, Senator Slama. Senator Doran, you're recognized to speak.
Thank you, Lieutenant Governor. I just listening to Senator Slama here. Would Senator Slama yield a question?
Senator Slama, would you yield to a question?
Of course, Senator Doran.
Thank you for getting into that amicus brief. As I sit here today, I know there's other things going on, lobby, everything else. So I may have not caught all of this today, but I talked to you a little bit about I think Senator Wayne and others have expressed concerns about that we will be back because of a Nebraska Supreme Court ruling. And this, I assume, is an amicus brief that's pertains to that. Explain that a little bit. Why now, if we pass the amendment, we won't have it in the bill, it won't be there anyway. But if I heard you right, it does not pertain anyway.
Yes, according to this amicus brief, like first paragraph, first page of the substance of this amicus brief is, this isn't a problem. So as we're looking at MP Dodge and Holcomb and going, oh, all these big scary things will happen under 1115. And I'd love if some of the people on the other side of interpreting this would get in and help me understand how this is such an urgent constitutional problem again. I would love it because I'm just not seeing as I'm digging into this case.
Right. Well, and that listening this morning, and I thought there was some good discussion this morning, that was part of the conversation that we were going to go down that path. The state of Nebraska, you're going to be involved in this because we don't meet, I call it the federal constitution that says you're right and you have a right to a trial and stuff. So this though kind of says that, oh, the state of Nebraska, now it probably doesn't pertain to this.
Yeah, so what we're looking at is an amicus brief that says not relevant. And the thing that was being pointed to is the big, scary, nasty thing as to we have to pass 1115 or everything's going to get compromised. We'll be in special session. All hell will break loose. Is a concurring opinion on this case. It's one justice's opinion. It's his opining that, in this possibility, there's a chance that maybe, perhaps, this might happen.
Then that gets to my last question. Today, as we stand here today, has there been anything, I call it in front of our Nebraska Supreme Court? Is there any challenge in there? Or with our Attorney General, is there anything under, I call it that avenue of a legal perspective that has there been something filed that says, yes, we're going to have this ruling by the Nebraska Supreme Court, or that hasn't gone down that path?
I'm standing willing to be corrected on this if somebody wants to hop in, but not to my knowledge. And I'd be really concerned if there had been something filed on point that we're just going, meh, we don't need that language anymore anyways.
Okay, good. Thank you. Thank you, Senator Slama. I see Senator Duncan here. Would Senator Duncan yield to a question?
Yeah. Senator Duncan, would you yield to a question?
Yes.
Okay. I don't know if you just heard that last question I asked Senator Slama. Has there been have we already, I call it, entered the legal aspect of it and gone down that path whereby Nebraska Supreme Court, you now need to give us guidance on this?
Yes. So what's interesting about the case that we keep referencing, which is that Holcomb case, is the ultimate decision they reached was that the majority of the court said that it was moot. Meaning we can't even reach an opinion about the other issues that were brought up. Now, in the original case, the issue of whether or not this is unconstitutional, our current statute was raised. But the court said, we don't even have to get to that. Thank you, Mr. President. We don't have to get to that because we're going to address it on another issue and we found it moot. That's why this concurring opinion exists. The concurring opinion says, listen, I concur, I agree, the issue before us today was moot, but if we were to have reached an opinion, here's perhaps what we would have said. And then it goes into a little bit more detail, actually outlining the amicus brief that was just discussed and pushing back on the amicus brief saying, here's what was said in the amicus brief, but here's why we disagree with that. And that's Justice Papik and a couple of others that join in. So in addition to that, my understanding is there are currently cases on point that are working their way through the system. I don't have the names of those cases, which ultimately will be appealed up. And by the time those go from county court to district court and then to the Court of Appeals or potentially being taken to the Supreme Court, then they'll reach a decision, assuming it's not moot.
Thank you. Thank you much. Thank you, Senator Slummer. Thank you, Senator Duncan.
Thank you, Senator Dorn and Duncan and Slama. Senator Duncan, you're recognized to speak.
Thank you, Mr. President. I actually punched in right before Senator Dorn asked me that question. So I was going to explain essentially what I just explained. I know it's getting a little bit late here. It is getting a little bit darker, but I wanted to just touch on that issue exactly. So the amicus brief that I believe was filed that Senator Slama was talking about, I was trying to listen back in the other room, was filed by the Attorney General, and it did talk about those summary proceedings, and it did say that's why it shouldn't apply. Earlier today, I kind of went into some detail about why the Supreme Court, at least in this concurring opinion, pushed back on it. And I think I talked a little bit about it, but it might bear some repeating. Given that he says in here, NP Dodge and the Attorney General took the position that an action for possession under 76-1446 qualifies as both a summary and special proceeding under these authorities. Although the exact definitions they offered for these categories were not completely clear to me, the Supreme Court says, they seem to argue that an action for possession under the statute is a special proceeding because it's codified in Chapter 76 of the Nebraska Revised Statutes rather than Chapter 25, and because it's governed by its own distinct rules of procedure as opposed to the ordinary rules of civil procedure. He then goes on to say, this argument, however, has some flaws. As an initial matter, the statement NP Dodge and the Attorney General rely on from Moores, the case that we're talking about there, is dicta. The issue in Moores was whether the jury trial guarantee applies to a quo warranto proceeding. Furthermore, other dicta, meaning other language in this case, in Moores is contrary to the argument of NP Dodge and the Attorney General. Moores quoted the other language from the same Arkansas Supreme Court opinion that stated, quote, "So far as our research has extended, the right of trial by jury at common law only extended to criminal prosecutions and in actions where a freehold or goods and chattels were in dispute. The term goods and chattels includes personal property, chose as an action, and chattels real. Chattels real meant interest in land which devolve after the matter of personal estate as leaseholds, Black Law's Dictionary, or more simply, a leasehold estate." Goes on to say, in any event, it's difficult for me to conclude that the language in Moores at issue would allow the legislature to remove an action from constitutional jury trial protections by, for example, codifying an action somewhere other than Chapter 25 or requiring that the action be completed in an expedited manner. Our court has never understood Moores to allow as such. And if we were to adopt that argument, I do not know what would prevent the legislature from enacting a statute codified somewhere other than Chapter 25 or with some expedited procedures that makes actions otherwise be obviously subject to the constitutional jury trial guarantee. So essentially, the arguments that were raised, the Supreme Court pushes back on and says, I understand where you're getting that from, but the language in the case that you're quoting that from is directly contradicted by the same case. Neither one of which, by the way, for legal folks who are watching, are the holdings of those cases. It's dicta, which means it's kind of things that are off on the sides of the actual opinion. And in fact, the legal analysis is separate and apart from that dicta about whether or not it should be a jury trial. So I am not a historian on a lot of these issues, but I do think that a number of other people have done the research about this. And the fact that, yet again, our Supreme Court seems to be implying this could be a problem, I think means that it potentially will be a problem. However, that has been taken out of the bill. And I understand that that is a problem. I wish we could address it. I wish we could add it back in. But when we asked our colleagues and friends whether we should do that or not, the votes weren't there. So this is not simply because we don't think it's important. It's because the rest of the legislature didn't think this was an important enough issue to bring up today. So hopefully we can address it in the future. I certainly don't want a special session. We keep talking about special sessions, and I know we keep hearing about that. But I do have concerns that if a case were to reach the Supreme Court, ultimately this would be their opinion. So colleagues, again, I rise just to kind of go into a little bit more history there. Maybe Senator Slama also needed a little bit of a break, so I'm happy to talk for a few minutes about that. I have an exec session to go into. Thank you, Mr. President.
Thank you, Senator Dungan. Mr. Clerk.
Mr. President, the Revenue Committee will be holding an executive session under the South Balcony now. Revenue Committee under the South Balcony now.
Senator Dover, you're recognized to speak.
Yeah, I just wanted to stand up and basically, we have a property management company that's licensed in '83. We've been managing properties since then. And one of my main concerns as I listen to the debate is, let's say that I understand there's a number of attorneys who help pro bono, and that's really good that they represent tenants. But my concern is this, is let's say that somebody, it could be didn't pay rent, did damages or whatever. So basically they go to court, and then the attorney who's representing the tenant says, hey, let's do this. I understand that they owe you 6 months of rent, and I understand there's $2,000 or $3,000 for the damage. How about we do this? How about we give you $1,000, you let the tenant stay there for another week, and then agree to let the action not to follow through with the eviction. And most landlords are going to say, if I can get $1,000, I'm not going to get anything otherwise or whatever, are going to take that option. Then the problem is with this one-time option is then they're going to be able to seal that. And so when we have, say that tenant then goes to another rental property and we do a background check on them, it's not going to show up. And so my main concern is I believe that there should be full disclosure. I believe that there's accountability. And I believe that there shouldn't be a way that someone should be able to have that action that was taken to be erased. And in most cases, I'll tell you, we've been managing a lot of properties for a lot of years. Someone is not going to take someone to court unless they absolutely have to. I can't speak to Lincoln and Omaha, but I certainly can speak to the Norfolk area. And no one is going to go to court for no reason. And I yield the rest of my time.
Seeing no one else in the queue, Senator Slama, you're recognized to close on your motion to reconsider.
Thank you, Mr. President. And Senator Dover's experience is really valuable here. And I hope like the few people remaining on the floor are listening, because this is not a process that landlords go into lightly. I don't know how else I can outline this. There's not people spuriously filing claims in court. Like, you have to file a notice to quit. You have to file a summons of forcible entry. You have to go to court, have your court hearing date, get through that, have the court do a judgment in your favor, and then within 10 days have a writ of restitution. If at any time during that process, the landlord and the tenant, and probably the tenant's attorneys, are able to come to a settlement or an agreement, or the tenant skips town before the sheriff can show up, that gets sealed. Doesn't matter the damage they did to the property, what was going on in the property, what misuse and abuse was happening with that landlord's property. Doesn't matter. It's sealed. So I am taking this bill to time. I'm hoping that a night of consideration will bring us to a bipartisan compromise. I'm fully in support of a bipartisan compromise that protects private property rights, that gets to this MP Dodge Holcomb case that's evidently that thing that we need to continue pointing to as being necessary to pass, otherwise we'll have a special session, but not important enough to where we're going to include it in the bill. Because for whatever reason, we're just not going to have that fight. So I'm going to keep talking about the MP Dodge Holcomb case, because it's that big nasty thing that we all pointed at as being the necessary thing for the bill. And I am at a crossroads here as to whether or not I'm actually going to take this reconsider to a vote, because we've got the Revenue Committee meeting under the South Balcony. I know the Judiciary Committee's in an executive session. Oh, Senator Decay's here. He's giving me a look of hope. He might have fled. Just kidding. Senator Decay's not on the floor right now. If you're looking for Senator Decay for the Judiciary Committee oh, there's Senator DeBoer. They must be out. Yeah, Decay's on the floor. And like, there's actually work getting done underneath the balconies, and I'm taking this time to protect private property rights. I don't know. I don't think the Revenue Committee is raising taxes with this executive session, so we might just, I don't know. I'm going to take my time on the reconsider motion and then withdraw it. I'm not going to take it to a vote. But here's why we're here. We've got a few more people on the floor because I think people sniffed out that there might be a vote coming. LB 175 is an attack on private property rights in the state of Nebraska. Even with the slimmed down version, even with the one free shot, you've got one free shot across the bow if you're a tenant to use and misuse and abuse the property however you'd like, and so long as you vacate the premises before the sheriff arrives to remove you from the premises, that gets sealed, and the next landlord you go to cannot look into it, cannot see the record of that eviction that was sought. And moreover, I do hope Senator Dungan can clarify this, because a concern that was raised with Senator Clements is if this person has eviction proceedings started against them for non-payment of rent, I don't even think the bank can see that. Thank you, Mr. President. And I think that's a problem from a practical standpoint, because if somebody is evicted for non-payment of rent, we're not talking about somebody who's 30 minutes late paying rent. We're talking about someone who's weeks late, and that should be something that the bank should know. So after this, the AM will be adopted. I've got another AM to the Judiciary Committee AM, and we're not going to get to a vote on this reconsider. What I'll do is just talk this through to 5 o'clock in our adjournment. Ideally, this won't be on the schedule until next week, and we can have the spirit of George Norris come through and possess us all to a bipartisan compromise that does not erode private property rights. And with that, I withdraw my reconsideration motion, Mr. President.
Thank you, Senator Slama. Without objection, so ordered. Mr. Clerk.
Mr. President, Senator Slama would move to amend with floor amendment 248.
Senator Slama, you're recognized to open.
Thank you, Mr. President. For those of you excited about a vote, there wasn't one, there won't be one. If you want to head home at 4:19, I guess, you can. Like, take that time if you've got it. If you're not in executive session right now, go home. Appreciate your private property rights, because right now we're dealing with a bill that erodes them. And here's where we're at. And I'm just going to repeat this because I like it when we keep debate relevant to a bill. Right now we are discussing a bill that has been amended and slimmed down to say that if you as a tenant are in the process of being evicted, you've done something so terrible that your landlord has had to go to court to ask you to leave. As in, you've asked this tenant to leave, they've said no. You've asked them a little bit more sternly and they've said, go away, this is my land now. And it's gotten to the point where you've had to hire a lawyer, file a notice to quit, posted that, or had the sheriff post it on their door. You've filed a court case saying, look, I'm serious. Now I'm getting the courts involved and you're going to be evicted. You've had the hearing date is passed. You've been evicted from the property, and within 10 days, the sheriff hasn't shown up yet, and you've said, all right, I'm out. I hear that you're asking me to leave. This is now weeks later in the process of you either not paying rent, destroying the premises, breaking the law, or doing some combination of those three. It doesn't matter like what you're up to. So long as you're out of there before the sheriff shows up to drag you from that property, the bank cannot see that you were evicted for non-payment of rent. Your future landlord cannot see that eviction court proceedings were filed against you for non-payment of rent, destruction of the premises, whatever reason that this landlord has had to take you to court, as in file an attorney, file all the necessary notices, pay all the fees to file against you to get you to leave his property. So long as you get out of there before the sheriff drags you out, you get one bite at the apple to misuse and abuse somebody's property as much as you want. And the next landlord that you go to can't even ask, cannot even ask about those eviction proceedings that were filed against you. Now, you might say, okay, it's one time, the person missed rent for several weeks, they hit a rough patch, what does it matter? Well, what matters is next year, we're all going, this is innocuous enough as a bill. Gosh, we're gonna vote for this. And then next year, you get unlimited bites at the apple. So long as the sheriff has not dragged you from the rental property, which is what this bill was before it was amended, you get unlimited shots at misusing and abusing somebody's property, and your next landlord has no warning about that. They can't even ask. And then the year after that, we're going to go with the originally introduced language of LB 175 that says even if the sheriff had to drag you from that property, so long as 3 years have passed, you can't ask about it. So yeah, I'm taking a stand for private property rights. We shouldn't be in this position in the first place. Ideally, I would have a card in front of me that says, yes, we have 25 senators that believe in private property rights enough to protect them by killing this bill, but we don't. So now we're going to take this to 5 p.m. We're going to have the committees get some work done. I know Judiciary's had an extensive executive session, Revenue Committee's meeting under the balcony. Like, work is getting done behind the scenes. So this is duly positive for the legislature, in one, that we're taking some time to protect private property rights, and two, that we're taking some time. I mean, for crying out loud, if we're to personal priority bills like these that just add more issues for a landlord to deal with if they offer affordable housing, like, we are moving too quickly with this session. We're almost through committee priorities. We're almost through personal priorities. And now we're to these little bills that are just little bites at the apple here and there of personal property rights, individual liberties, where we go, meh, I don't want to filibuster it. I've got stuff to do. You know, I could be hanging out with my baby right now. He's really good company, and he doesn't try to take my rights away. He wakes me up at 3 a.m., he takes my sleep away, but he's not in the legislature going, yeah, landlords shouldn't be able to ask if a tenant destroyed the last property where they were at, so long as the sheriff does not drag that person from the premises. So yeah, I'm gonna take 8 hours to stand up for private property rights, form a legislative record, because next year, I'm not gonna be here to take 8 hours on the originally introduced language that says you get unlimited bites of the apple, even if the sheriff has to drag you off the property, so long as it's been 3 years. I'm not gonna be here to form a legislative record when next year we're pointing at the NP Dodge case of, oh my God, we have to pass this all-encompassing bill, LB 1115, to ensure right to a trial by jury, because we're going to be in a special session, because now suddenly it's not an issue. It's not an issue that we're going to try to address. Like, if we're going to genuinely point out issues, like, let's not say special session. Let's not scream fire in the movie theater unless there's actually a fire. Like, I'm all for a bipartisan solution on the language in the concurring opinion by Justice Papek in MP Dodge versus Holcomb. If we can find some narrow compromise, that's fine. But I'm not going to sacrifice private property rights, tie landlords' hands, and make it this big scary secret that a tenant destroyed the last property they were at. So I'm going to get back to this brief that the Attorney General filed on the MP Dodge versus Holcomb case, saying that you don't have a right to a jury trial under Article 1, Section 6 of the Nebraska Constitution with these landlord-tenant possessory actions. Because even though it's no longer part of the bill, it was tied up as this thing that we just had to do. And I think people came in from their afternoon and they were like, oh my God, yeah, this is the thing that we have to vote for to avoid a special session. Because if you yell special session in a place where you make 12 grand a year and you don't get any extra pay, if you go into a special session and you have harvest in September, yeah, that's a problem. I get why people came in from their executive sessions and voted for the amendment. And I'm going to keep pounding the fact that not only is LB 175 as a baseline bill a problem, I'm also going to get into MP Dodge versus Holcomb and why LB 1115 was just a red herring when it came to a special session being promised. So I understand why we're here today. I'm hoping we've got some senators on the floor right now that believe in private property rights. If you do, if you believe in small government, you'll stand with me in opposing LB 175. We took a test vote on this and the votes weren't there, so that's why I'm filibustering it, so that I can protect private property rights, even if nobody else wants to. So thank you, Mr. President.
Thank you, Senator Slama. Senator Lowe, you're recognized to speak.
Thank you, Lieutenant Governor. We were just going over Statehood Day and how much fun it was. I would like to thank my wife for putting that on and being executive director. We all had a great time. I am still standing opposed to LB 175, and it takes away our freedoms. But I know you're all anticipating my report on the basketball game that was happening. The Lady Lopers were playing down in the MIAA tournament down in Kansas City, trying to make it into the Elite Eight. With 2 minutes left, it got within 2 points of playing Washburn. And then slowly, everything just kind of bounced back and forth for a while. And with a minute left, there was still at 2 points. and it didn't look good for the Lopers. But then they fought back and they won 72-65. So the Lady Lopers are in the Elite Eight. So good for them. They won. The Lady Lopers won. I'm giving Senator Slama a brief break here so that she could rest and get ready for the evening. You know, as we look at this bill and it's as we see now that it's not needed, I think that we ought to just vote this thing down, but I don't believe we have the 25 votes to do that. I think it needs to die a slow and miserable death, and that's kind of what we're doing now is we're going to take this till 5 o'clock. And I'm sorry, but I've already talked about being a landlord and about the tenants, and now we try to take care of our tenants. I know Senator Slama has talked about the process it takes to remove somebody, and it's not a pretty process. They've been given multiple chances to redeem themselves. As I've said, I've let some of my tenants go for a month or two because I know they're strapped, and I know maybe their employer is strapped and they weren't able to get paid fully. So we work with our tenants. It's what we do out in Kearney. We had a famous landlord out there for a long time, and he passed away 6 years ago. Jerry and I were good friends. He was notorious for taking his tenants to court because he wanted his money, and he knew if he let them skid by for a little bit that they weren't going to pay. But he was also a very generous man, and he worked with his tenants, and if he knew that they were going to pay, he would let them go for a while. That's what good landlords do. And I believe Nebraska is made up of mostly good people. As the governor says all the time, when people come to visit, they say, what is it that makes Nebraska special? It's the people. And that's what we're talking about here. It's the people. The people that want this bill to pass probably are not the best people in the world. They've probably been given multiple chances to pay their rent. They've gone through many processes, and now they're going to court. The court where the landlord has to hire an attorney.
1 minute.
Thank you, Lieutenant Governor. Where the landlord has to hire an attorney. So not only are they out their rent, they're out the fee that they pay to an attorney. And so that's even further backwards. And like I said before, most landlords don't own their property wholly. It's the bank that owns them, and it may not even be the local bank anymore because the local bank has sold that note off. And as Senator Clements brought up to me, that it's not the banker's money that he's loaning out. It's not the bank's money it's loaning out. It's you who have deposits in the bank. That's the money he's loaning out. It's your money that's not being paid back to the bank. So we have to think about that. That's the way freedom works. Thank you, Lieutenant Governor.
Thank you, Senator Lowe. Senator Dungan, you're recognized to speak.
Thank you, Mr. President. So I just wanted to get on the mic and I think just answer a couple of questions that have been brought up. So I think Senator Slama, in talking about the process and the procedure of how this all goes down, made some comment with regard to the fact that if a tenant were to set this for a contested hearing or currently sets it for a contested hearing and then doesn't show up, the action can't move forward. That's actually incorrect. And I have talked to multiple people who do this for a living. And my understanding is our current statute actually says there's provisions for this. In the event that a tenant sets this for a contested hearing and then does not show up, the matter will proceed as though it would in any other circumstance and be heard on the merits. In fact, I think in some places it's actually just a default judgment. It's over, so it's actually quicker. And so the eviction can ultimately be executed and the writ can be executed if the person doesn't show up. So the eviction goes forward. So if a tenant wants to set something for a contested hearing and then bails on it, it's actually easier and quicker for the eviction to be done. It doesn't just not happen because the people who wrote those statutes understood that that was a possibility and they ensured that that would be covered. That's actually one of the small tweaks that we originally had worked with on 1115 when that was still being discussed to ensure that if a jury trial was requested, and then a tenant did not show up at that jury trial, that the jury would be dismissed and the matter would proceed either with that default judgment or as it would in all other circumstances as though the person were there. So we have addressed that problem and it's not an issue that I'm concerned about. So I just wanted to make sure it's clear to anybody listening at home or any of the fellow senators who are paying attention to concerns that in our current landlord-tenant statute, if a tenant does not show up to a contested hearing, it doesn't just disappear or go away, the landlord actually just wins. So that's very clear. Second of all, I just want to comment briefly, I think, on the unintentional, potentially problematic comment that was made earlier that the people who want this bill to pass are probably not very good people. I find that very problematic. I think that, first of all, there's a number of people in this body who I think want it to pass, and so I'll just assume that's not who we're talking about. But in addition to that, the people that oftentimes are dealing with evictions are usually pretty down on their luck. I've seen these people, I've interacted with these people, I know these people. We're not talking about bad people. We're talking about people who have circumstances, sometimes beyond their control, that has put them in a situation where I'm pretty sure none of us would ever want to find ourselves. And are there bad actors? Sure. But I don't know how many times I can repeat on the mic today that 99% of landlords are good actors and 99% of tenants are good actors. And you have the 1% bad actors on the outside that become the anecdotal evidence for why there's so many problems. And the individuals who struggle to pay rent are not inherently bad people. We're talking about people in marginalized parts of society. We're talking about people who maybe are dealing with any number of mental health issues or substance use disorder issues, things that everybody in this body agrees we should be working on. So I just want to make very clear on the record here in the Nebraska Legislature that not everybody who wants this bill to pass is probably not a very good person. With that, I would continue to encourage my colleagues to support LB 175 with the very, very, very pared down language that we've put together. Again, that is the language that we could get through here today. I wish more of my colleagues were concerned about some of the issues we brought up earlier, but unfortunately, this is just where we find ourselves. I still think with this language in the AM, LB 175 will have a significant and real impact on those who need some help, but it is a compromise. And I appreciate the fact that others have been talking and raising concerns with me, and I'm still happy to have conversations between now and select about additional modifications that would be made or could be made. Thank you, Mr. President. I think that I've made it very clear I'm willing to compromise and work with people, and I appreciate those that have been willing to do the same with me. Thank you, Mr. President.
Thank you, Senator Dungan. Senator Slama, you're recognized to speak.
Thank you, Mr. President. Good afternoon again, colleagues. Let me hit my light so we don't waste turns on the mic here. So real quick retort to Senator Dungan. Of course, if you're in a situation where you're not paying rent, God knows what's going on. So any comments made by anybody on the floor isn't intended to attack any tenant that's not paying rent as automatically not being a good person. But here's the thing. There's been a lot of vilification of landlords here too. And I hope, if you've gotten nothing else out of today's discussion, that if we're going to court to get a tenant off your property, I'm going to be very careful with my wording here. But if your landlord has come to you, said, you need to leave, you've said no, and they've found it fit to pay the court fees, pay the notice fees, hire a lawyer, odds are you're not a spectacular tenant. And there is a broad range of possibilities here. It might be somebody who is genuinely just down on their luck and it's a terrible situation, and you've got a landlord that is exploiting someone who's in a terrible situation. 2, somebody could be destroying your premises You've given them extensions on rent. You see that they're destroying your property. You're asking them to leave. They're not leaving. And now you have to go to court for the first time in your life to file an eviction action against somebody who is actively destroying your property. And the only thing you can do about it is go to court to try to get rid of them. Now, Senator Dungan did point out something that I think is very valuable for us to talk about, in that in the proceedings, if the tenant fails to show for court, which I do think is an issue inherent in our landlord-tenant laws, it doesn't provide a lot of flexibility for somebody who is a tenant if they cannot get off of work. We ran into this problem quite a bit, especially in the aftermath of COVID, when evictions started picking up again. People couldn't get a shift off of work, so they were unable to attend their hearing. They had a default judgment filed against them. However, what I'm talking about is being a loophole in this law that Senator Dungan doesn't want to talk about, is if this person refuses to vacate when being asked too nicely, refuses to vacate when being asked again, not so nicely, refuses to vacate after being given notice of a court hearing against them, shows up to the court hearing, makes a case as to why they shouldn't be evicted, has a judgment filed against them anyways, and then has the chance to vacate the premises before that writ of restitution, which is the ruling you get in order to evict a person through the court. So long as that person heads out and goes on their merry way before the sheriff's office shows up within 10 days to remove them for you, that's their one bite at the apple of the next landlord cannot ask about that eviction. Cannot ask about that eviction proceeding, cannot ask about what happened there. So yes, if that person doesn't show up and there's a default judgment, yes, that goes onto the record. However, thank you, Mr. President, if that tenant is really dragging things out, and so long as they're out of there before the sheriff drags them out, so they show up to court, they do everything, the court still rules against them, and we're within that 10-day window of the sheriff can remove them for you, so long as they leave, that falls under the exception of LB 175. So when we're saying that this is a narrow bill, that this has been negotiated in good faith, it hasn't been. And I'm not feeling the spirit of compromise when the compromise amendment was negotiated with the actors in the lobby and not the senators on the floor. So when it comes to process and procedure, yes, that is going to encourage me to take 8 hours, not only to protect private property rights, but to protect the process of the legislature in dealing with senators themselves. Thank you, Mr. President.
Thank you, Senator Slama. You're next in the queue, and this is your final time before your close.
Fabulous. Okay, so I'm going to take this chance to get into the amicus brief on the MP Dodge Holcomb case, because I'm sure that the attorney at the AG's office who wrote it out really is proud of their work, and the AG's office just really does great work. This was filed under AG Peterson. We now have AG Hilders. I think if you ever have the chance, you should go visit with some of the attorneys in the AG's office. They're some of the hardest working people for some of the lowest pay you can get as an attorney in the state of Nebraska, while doing some really, really good work. But summary of argument, the county court did not err in denying Holcomb's request for a jury trial in this landlord-tenant possessory action brought under the Uniform Residential Landlord and Tenant Act, URLTA. The right to a jury trial protected by Article 1, Section 6 of the Nebraska Constitution does not attach to landlord-tenant possessory actions under URLTA because they are summary in process, equitable in nature, and substantively distinct from 1875 ejectment and FED actions in Nebraska. Nebraska courts have never directly addressed whether special or summary proceedings fall within the constitutional right to a jury trial, but many other states' Supreme Courts have, and they widely accept that the right to a jury trial does not attach to special or summary proceedings. This court should follow suit. Once the court officially adopts that rule, it should conclude that landlord-tenant possessory actions in Chapter 76 of the Nebraska Revised Statutes are special summary proceedings. Such proceedings generally reside outside of Chapter 25, and these landlord-tenant possessory proceedings meet that characteristic since they are found in Chapter 76 and not governed by the ordinary rules of civil procedure. Additionally, landlord-tenant actions are summary in nature. They are designed to be resolved within days or weeks, not years like a typical civil action. The constitutional right to a jury trial applies only to legal, not equitable actions. That inquiry is determined by looking at a suit's, quote, main object as disclosed by the averments of the pleadings and the relief sought. That's from Ihusen versus Ihusen, 272, Nebraska 462, 467, 723, 2006. Here, the main object of the proceeding was to obtain an order directing Holcomb to leave the premises. Such an order is akin to an injunction or a command for specific performance, standard forms of equitable relief. Though Holcomb tries to place landlord-tenant possession actions in the same camp as common law ejectment and FED, those actions are distinguishable from this one. Common law ejectment is a slow, complex procedure, much different from the expedited process under the URLTA. And historical FED actions were criminal proceedings involving violence or force. Possession actions under URLTA are not criminal in nature and need not involve violence or force by any party. Even if Holcomb is correct that Article 1, Section 6 of the state constitution, quote, preserves the right to a jury trial as it existed under statutes in force when the Nebraska Constitution was adopted in 1875, the landlord-tenant possessory proceeding brought here does not exist in 1875. It was not created until 1974 when the legislature enacted the URLTA to modernize, thank you, Mr. President, landlord-tenant law. Holcomb tries to parallel the present action with Nebraska's ejectment and FED actions as they existed in 1875, but the comparison is unavailing. Ejectment was broad, covering any action for the recovery of real property, but this URLTA suit is much narrower, applying only to landlord-tenant relationships arising from rental agreements for real property. So I'm going to leave it there. I'll continue reading this up until we get out of here for the day. I think John Kavanaugh is going to hop in. We've got maybe one more person in the queue, and then I'll have my close and make sure everything's filed to take care of things tomorrow. But that should really take us to the close of things today. But yeah, you know what? I'll take 8 hours to protect private property rights in this state. Thank you, Mr. President.
Thank you, Senator Slama. Senator Lowe, you're recognized to speak.
Thank you, Lieutenant Governor. As we're speaking on landlord-tenant rights, I want to explain kind of what happens when you have somebody come into your house that you have and you really don't know what they're going to do, and they actually do something that you have to evict them. And as you go in and inspect the house, I like to replace the furnace filters because it gives me an excuse to go in and inspect to see how the house is going along. And luckily, I've only had to do one of these in the last 35 years, and it was early in my career. But our family, we don't hire a management company. We are the management company, and my two brothers and sister, we take care of our own places. My youngest brother and my sister have both moved to Colorado and live out there. So it's my brother and I that handle our rental property. And I've been down here for 8 years, so he's been stuck. So I think I owe him some time here in about 6 months to go back and help him out. But when you have a person that is in your dwelling and you've put an eviction on him, he knows he's got time. He knows he's got time to live there, and he's going to have this on his record, so he really doesn't care what he does to your place. If he has a pet, he no longer lets the pet out when the pet needs to go outside. If he wants to throw a party, he can do that, and he doesn't care what people do inside the furnaces or off on the side of a wall or anything like that. They'll knock holes in your wall because your only recourse is the deposit, and he knows he's already lost that because he's being evicted. They'll also tear up the carpet and break other things. So once he's been evicted, once this tenant has been evicted, and now you got the right to go in there because they're no longer there, first thing you do is tear out the carpet, then the linoleum. Then you start on the walls. You may have to replace all the plasterboard on the walls. You work with the ceiling. There may be holes in the ceiling. The lights may have been pulled out. This is not a cheap thing. It's very expensive for an eviction. That's why you want to work with your tenants ahead of time. You don't want them to go to eviction. You want to work with them. You want to make sure that they have a good job. I have found my tenants jobs, better paying jobs, just so they can stay in a place. That's what good landlords do. Because by finding the occupant a better position, they will be better occupants. They'll have more pride in themselves. We need to do this occasionally, but it's a whole lot better than having to go in and revamp a whole house. Heating system, refrigerators and stoves. I had a tenant leave on the stove one time intentionally. This is the same one that I evicted. He left the stove on.
1 minute.
Thank you. For 4 days straight because he wasn't going to pay the electric bill anymore either. It ruined the stove. So you look and you say, well, you know, the tenants, we have to look out for the tenants. We do look out for the tenants. And it is the ones that don't want to cooperate. That's what this bill is trying to affect. By allowing them to go back into another dwelling after they've destroyed one. Good tenants we don't worry about. People that are back a month, maybe even 2, we're not too worried about. We are worried about the ones that are willing to destroy our property. And like I said, it may not be our property. The bank still has the loan.
That's your time.
Thank you.
Thank you, Senator Lowe. Senator John Kavanaugh, you're recognized to speak.
Thank you, Mr. President. Colleagues, we're almost at the end of the day, but I couldn't resist. I was listening to the conversation, and this is one of the reasons we have these conversations is because Senator Slama's made some interesting points, and I was going to ask her to yield to a question. If Senator Slama wants to yield to a question or be back at her desk, and I'll drone on for a minute. But
Senator
in just a second, Mr. Lieutenant Governor, I had a point to make before I asked her to yield. I was giving her Cliff's notes. But one of the reasons we have the conversation is Senator Slama's raised some points that I thought were interesting that I do think I was curious what the answer is. So I appreciate her work on this bill today in this conversation, and I think we do need to answer this question. So would Senator Slama yield to a question?
Senator Slama, would you yield to a question?
Yes, sir.
So Senator Slama, you've been talking, I think it's on it's on the amended version, 2908, page 3, and I think we're talking about you were making the point that if someone vacates the premises after a landlord goes through eviction, gets a writ, and the person vacates before the writ is delivered, you were saying something to that effect, meaning a loophole in it. Could you clarify on that?
Yeah, no. So what I'm saying is under sub C, of that section is if you go through the proceedings, the court rules that there will be a writ of restitution executed against you. Where I think we're going into the back and forth is what executed means. So I'm interpreting executed as the sheriff is executing the writ of restitution by forcibly evicting that person from the premises. We're dragging you off. Where I think you might be taking execute a different, I don't want to speak for you, but I think you might interpret execute a different way. And I think that's good to debate. That's very good to build the legislative record on. And before we do go for the day, I do need to apologize for the presiding officer. I've tried to be like very polite during this whole thing, but I've given him just a ton of stupid extra work. So I apologize on the front end. But yes, Senator Kavanaugh.
I appreciate that. Yes, and you're right. We are having a bit of a difference of opinion about, the one word of what executed means. And actually, I corrected, yes, page 2, line 11, section C. And so I appreciate your clarification on that. And I would wonder if Senator Dungan would yield to a question.
Senator Dungan, would you yield to a question?
Yes.
And thank you, Senator Slama. I didn't say that before, but Senator Dungan, I assume you just heard the conversation between myself and Senator Slama?
Yes, I did.
And you know where we're at on the executed under section C on page 2, line 11, says following the eviction proceeding, a writ of restitution is never executed?
Correct, yep.
So what would be your interpretation of what would executed be?
So under Nebraska Revised Statute 761446, which is the part that actually specifically talks about the writ of restitution, which is what we're talking about here, it specifically says that at the request of the plaintiff or his or her attorney, the court shall issue a writ of restitution directing the constable or sheriff to restore possession of the premises to the plaintiff on a specified date, not more than 10 days after the issuance of the writ of restitution. So the execution of that writ, which generally I think colloquially would be the completion or performance of that writ, would be to restore that premises to the possession of the landlord. So I don't think it has anything to do with whether or not the tenant is present or the tenant is served with anything. If the tenant's abandoned that property, that writ is properly executed so long as the constable or sheriff restores that property to the landlord. And I think that that's a plain reading of that. And I think Black's Law Dictionary also talks about the word execute meaning to perform or complete a duty. So if the point of the writ is to restore that property to the landlord, it has been executed, upon which time that landlord then has access to that property again.
Okay, thank you.
1 minute.
Thank you, Mr. President. Thank you, Senator Dungan, and thank you, Senator Slama. So, colleagues, this is a great example of an opportunity where we discuss a bill and in the process of discussing it, we come to a point where there is a difference of opinion about what the bill would actually do if it goes into effect. Because Senator Slama is pointing out a concern that if we do, against her wishes, adopt this and make it law, it will have a bad effect. And Senator Dungan saying, if you interpret it this way, it will not have that bad effect. So it's really important to have these conversations in this kind of constructive way and to drill down on those things. I appreciate the definition from Senator Dungan and the conversation from Senator Slama, and we'll probably pick this up tomorrow. Maybe we'll be able to drill down on that to parse this a little bit more, which is a fun thing for some of us lawyers who like to parse one word for hours at a time. So thank you, senators, and thank you, Mr. President.
Thank you, Senator Kavanaugh. Mr. Clerk.
Mr. President, your Committee on Enrollment and Review reports Legislative Bill 1288, 1118, 1143, 877, and 998 to select files, some having E&R amendments. Additionally, your Committee on Enrollment and Review reports Legislative Bill 771A as correctly engrossed and placed on final reading. Your Committee on Revenue, chaired by Senator Linehan, reports Legislative Bill 1032 to general file. Amendments to be printed: Senator Dorn to LB 1108, Senator Hunt to LB 62. Motions to be printed: Senator Slama to LB 175. New LR from Senator Dover, LR 318. That will be laid over. Appointments to the Legislative Oversight Review Special Committee as appointed by the Executive Board. Additionally, name ads: Senator Decay to LB 896, Senator McDonald to 903 and 1221, Senator Erdman name withdrawn from 1061, and Senator Wayne name withdrawn from LB 1370. Finally, Mr. President, priority motion. Senator Boston would move to adjourn the body until Thursday, March 7th, 2024 at 9:00 a.m.
Members, you've heard the motion to adjourn. All those in favor say aye. Those opposed, nay. We are adjourned.